Please be seated. Computer's going. This is case number 2018 CA 5321. Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs, let's take appearances, please.
Greg Anderson, Nick Whitney, and Samantha Lawrence on behalf of the plaintiffs.
Howard Hunter, Ethan Shapiro, Pat Crowells, David Hughes, and Chris Altenbrun on behalf of Johns Hopkins All Children's Hospital. And our corporate representative today is Dr. Richard Elliott.
See Mr. Altenbrun's here in the courtroom. I did receive the further edits to the instruction. I know I think there were 3 changes. On page 2, I'm still not enamored with the proposed sentence disagreements concerning her treatment could be addressed by the dependency court. So my thought is we just don't stay that right this second, and we'll continue to have discussions for the final version.
So when do you plan to read the final version?
Well, my understanding is you all wanted me to read this today, and then we were going to have a written version that would go to the jurors with the collection of jury instructions.
Okay. Especially in the written one, I'm concerned with it ending in to participate in decisions concerning your treatment, because I think it needs more.
And I think we need to come up with some language that I can live with, you can live with, and the plaintiffs can live with. And I just don't think we're there on that one sentence yet.
Okay. I had suggested a minor change to the sentence on page.
On page 4.
4 it is. I'm sorry, the blue highlighting, at least when it prints out, is darker than
My view on that, instead of using the word direct, let's use provide. So it would say the dependency court did not provide that Johns Hopkins could supervise the calls.
Okay.
Okay, I think we're threading the needle the best with that word.
Okay.
Your Honor, last night, for the first time, I had an opportunity to review the proposed order, and I took a stab at revising our version of it. You should have it right around now. I know you're invested in this one. I did not get a chance because, I'm falling asleep with the computer on my chest trying to get ready for the next day. So I finally got 99% of it done. You should have it, all counsel should have it within the next 5 minutes. And I would really like to take a stab at helping, because I read through this, and just from trial counsel's point of view, I think it is going to raise so many questions with the jurors at this point that it's going to add days to this trial. And I honestly believe that. I want this to be as efficient as I can. I want both sides to have a fair shake at how to handle these orders. But I think there's a way to cut out a tremendous part of this. And my theory is this, that now that we have the history to compare to the orders, there's a bunch of terms, conditions, and in fact orders, such as the birthday order, which really have no bearing. There's no continuous time frame or alteration of time frame that would affect the jury's deliberation. So what I tried to do was, and I know nobody's seen it, and I apologize, just ran out of sleep time, I don't know. But my thought is, if we can trim it down to the essence of those points that describe what they need to know as opposed to all of the orders, I think it would be more beneficial. And so that's what mine attempted to do. And again, I wish I could have gotten to it sooner, but I just got to prepare for trial too. So But perhaps over lunch, the court would have an opportunity to go through our proposed order. It's not brand new. It dovetails off of.
Well, let me ask you this. Are you just cutting things out or are you altering language?
Both. Both. But I think at least opposing counsel has seen the version that I was working off the one that you and Mr. Altenberg and Mr. Elliott were working on. So I think there is, again, quite a bit of it that is the same. In terms of the direct, when the court did the direct quotes of the orders, that's left in. It is simply cutting out some.
I'm not even sure he's looking at
The old order, I just don't know how to
most recent
respond.
version
Okay.
at this point. Honestly, because we don't have direct quotes in the version
Yes,
where
it
we're
is.
at.
Yes.
Yeah, I don't think he's dealing with.
My position is that we wanted to give this to the jury sooner, and admittedly, it's complicated, it's taking time, but the longer we wait, the more confused the jury remains on me.
Well,
I completely disagree. I think that this is
hang on,
not
let's do this. You say you have sent it or are sending it momentarily?
momentarily. Ms. Stunt is she sending it right
She
now?
sent it, yes.
All right, you should have it. The court should have it. Counsel should all have it. And I have a printed copy.
Mr. Altenberg, were you going to be here today or were you just coming this morning
I
for
was
this issue?
planning to make a cameo and go back and work on jury instructions, but I can stay a little while longer at least. But I will tell you on the jury instructions, I think we should have a packet to you hopefully by, I'm not sure how soon you want it, but by sometime early this afternoon. The biggest concerns in that packet, at least from my perspective, are on the count 14 stuff. We're getting close to when we're supposed to rest, and I still don't know what the issues are, whether it's going to be a standalone negligence claim or whether it's going to be fitted in to med mal. Right now, what they're sending me is a standalone simple negligence claim that our training caused damages without any reference to a doctor being negligent in the interim. So there's problems with that one that I really need to understand before we can rest.
And do we have a verdict form draft coming with it?
We're in the midst of that, but I think we can make great progress on that today.
I mean, I would like, and I know you and Mr. Elliott are working hard on making it happen. I don't want to give you a deadline,
Right.
But
I mean, I think we can
I'm
give
in
you
the
something
point.
that's a working document by tomorrow. I do. But some of it depends a little bit on some of the jury instructions, but I understand the format he wants, and I think we can probably work together on that today quite a bit. I understand that he has a law school reunion this weekend in Boston, and he's not going to be available for much this weekend, I guess.
Well, the sooner that you can get it to me, the better. I get that's the best. I don't want to put a time limit on it because I don't want
Right.
to impact what you and Mr. Elliott.
And could I suggest that it'd be faster and easier if I can get you kind of the questions they're going to answer yes and no, and the elements on damages without worrying too much about the formatting of it, because the formatting of a verdict form is doubles time for me.
I'm probably going to end up doing the formatting
Well,
myself.
and that's actually what I told Mr. Elliott.
So I'm not worried about your formatting so long as
Okay.
it is in logical. We'll
Again,
clean it up.
I think by tomorrow morning, we can give you the logics of this and the language pretty close to what you need to work with. So, now, I will make that as my goal, even if I say late this evening, trying to do it. So.
Ms. Syback just brought in, I guess, Mr. Anderson, so I can hand you this. And
Yes, 'cause I
Ms.
don't-
Syback can print me another copy and bring that in. If you want to make a cameo again right after lunch
On this and the other thing,
on that issue,
I'm happy to do so.
and that way I don't hold you here, but
And I can give you progress on what we're doing on the other things by that point.
Bob Ray.
But on let's close the loop on this. I really want this issue to be put to bed coming out of lunch. So,
Should I get with council first and then talk to the court?
well, he's got your work product, so can he take your work product and then if necessary, talk to Mr. Elliott this morning?
Absolutely. Absolutely, that was the intent.
But, I don't know,
May I ask, this isn't a red line, this is just a set of changes?
There's a red line version
Okay.
emailed to you.
Okay.
Well, I'm absolutely confident both Mr. Altenberg and Mr. Elliott are horrified at the thought of trial counsel getting in on their instructions. Anyway,
well,
I would attempt.
I'm told the copy that was served is not red line. I'm not sure I can tell on my
It's
phone.
not, one email that we're looking at has no red lines on.
did you get a red line version?
I'm sure we can get the red line version over.
Yeah. Okay. If we get a red line version, she can print it and we can give it to you, Mr. Altenberg, and then you can take off.
If
Or,
they serve it to me by the time I get back to my
great.
alternate office, I can print it out there.
Altenburn Office South.
Yes. And you want me back here at 1 o'clock, right? I'm happy to do that.
I don't know what time we're gonna take lunch today because I don't have
At the end of
a
lunch, shoot, when you want it.
correct. So
All right.
hopefully around 1-ish.
All right. Thanks a lot.
And I want to be clear where the defense is on Fabre. They've been stating that they were making a decision, that they made a decision on.
We have not.
I should have a decision by lunchtime.
Okay.
What's next?
Judge, I have exhibit I need to put in before the witness this afternoon. It's a new exhibit it's not a new exhibit. It's an exhibit that the plaintiff has put in, but I've divided it into two packets because the defense position is that there are morning photos and there are afternoon photos. And so they merged them all together and mixed them up. So I divided them up. So I would like to admit 3401.
Is this on this list?
It should be on the list. It is on the list. Not the one. It's the last exhibit. I'm sorry, to put it in order, there's 3400. And I've given a hard copy of this to the plaintiff counsel, 1 through 14,
We object, but I'll wait.
and 3401, 1 through 9.
Okay, and so
Okay.
just tell me what these are before we look at
Sure.
it.
Here's the deal, Judge. They put all these photos, they're already in evidence, all of these photos. They mixed them all together. You could tell by looking at them, in some of the photos, she's in blue shorts, and some of the other photos, she's in pink shorts. They merged them all together, they're all mixed up.
Is this the before and after court?
Correct, Your Honor. So I divided them up by before and after court, and I want to use them in that fashion with the witness, because otherwise it's totally confusing for me to be able to use the exhibit. It's the same exhibit, simply divided into morning and afternoon.
So all of these exhibits are already in,
That's correct, Your Honor.
and it's just a reorganization and putting them. So what's the issue, Mr. Whitney?
Your Honor, first of all, they're already in. They can make the argument about blue shorts or pink shorts without putting this photograph into evidence twice. Secondly, what they've labeled as 3400, you'll notice, is not bait stamped. 3401 is. So the accusation that we mix these all up, we don't know the progeny of 3400 since there's no bait stamp on those.
Well, how about 3400-2? Are there any bait
There's
stamps?
no bait stamp on, I just looked at all of them. Anywhere in 3400, there are no bait stamps.
Judge,
And we must say, Judge, that our information.
Can we go back to just one
Yes.
lawyer per subject?
Yes, sir.
Thank you.
Judge, I don't recall if their exhibit has bait stamps on them, but we can put the bait stamp on there if that's the issue.
Were the ones that came into evidence already, did they have bait stamps?
I don't recall, Your Honor. I don't know if they just had exhibit numbers, if they had bait stamps. Perhaps counsel can.
They did, Your Honor. Ours had bait stamps, and
Can you give me just tell me the exhibit number that's in evidence and pull it up real quick?
it looks like 2604-006, 2604-001.
Let's just pull up the first one.
2604-006, 2604-001.
Yeah, those are on.
And you'll see these have bait stamps.
Well, Judge, we can put the bait stamp back on if that's truly an issue. I mean, there's no question they're the same photos.
And all I'm seeing here are 3 photographs. I don't know if I'm sorry. Oh, they're not here in front of me. Okay. They all have bait stamps. We introduced them in the way they were produced to us. So the mixing up of order is not the blame doesn't go to us for that. This is the way the hospital produces them with bait stamps. We put them all in evidence. They can make their argument about blue shorts or pink shorts. There's a factual dispute about whether there were before and after photos. Of course, they take the position there were. Maya Kowalski says it happened one time. Kathy Beatty forced her in a dress in front of her and changed her before court. That's a factual issue that they can take up with the photos that are already in evidence.
We'll be happy to put the bait stamp numbers on. I think probably Dr. Leder, when we put the new exhibit number on, happy to put the same bait number now so they can do a comparative analysis. They're clearly the same photos. It would be, I do not want, I think the defense has the right to have the jury see these as 2 separate packets, one before and one after, as opposed to getting them all mixed up when they're back there in the jury room.
The other point I need to
Clearly,
make-
I'm sorry.
Oh,
Go
sorry.
ahead, Ms. Quarles, you can finish.
Sorry.
These are clearly, in our view, and the testimony will be, 2 separate photo sessions.
The other point I need to make is there's no date and timestamp to confirm that. What's the point of putting them in this fashion? They're already in evidence. They can make their argument. If they were timestamped and dated differently, if one was a morning set and one was an afternoon set, from the face of them, perhaps. But that's not the case.
I think at this point, Ms. Quarles, if these photos are already in, let's just go with what's already in. I don't want to, if Mr. Whitney is correct that these were produced in a different fashion and not as a coherent set, I don't want to be seen as glossing a coherent set. If they're already in evidence, let's just go with them as in evidence.
Okay.
Next issue.
Just as a matter of scheduling, the court had told the plaintiffs yesterday when we tried to publish emails, whether we could just publish them or need to publish them through a witness since we're running out of trial days. The court asked the plaintiff to make a commitment this morning. So we would like to hear from the plaintiff whether they would require us to call a witness to publish or if we could just start publishing.
Anything further on?
I'm sorry, I would have been. We were not allowed to do so, Judge. We had to put ours in context with a witness, with the court's ruling. We do not believe that it is appropriate nor particularly time efficient to stop the testimony to simply have the jury stare at the screen for a minute on each one of these. So we would object to just simply having them put in without a witness, any context or anything else.
Did I allow the plaintiffs to publish without a witness? And I'm not talking about a situation where we had a deposition and then published exhibits that occurred in the deposition, but did I allow plaintiffs to do this?
I did not. During the course of what I was doing, unless Mr. Whitney remembers differently, during the course of what I was doing, we did not have that, and we actually asked for it within the first week to be able to put some of the documents into evidence before we had a witness up. We were not allowed to do that. The court wanted it to be in context with a witness if we're going to bring them in, and it's a waste of time here to just have the jury stare at these. I mean, at least to have some context.
The court did allow them to publish, for example, policies and procedures at the hospital without calling a witness. In terms of efficiency,
Was that in relationship to a deposition, or did I just?
I believe, my sincere recollection is you just let them publish. In terms of efficiency, it's going to be far more efficient of the court's time for us to just publish, let them read, than for me to call a witness and walk them through. If they're going to require me to recall an expert, or require me to call somebody like Dr. Rich Elliott as a teammate.
Here's my thought.
Yeah.
I don't want to just force people to spend money to publish a document that's in evidence. I think at the bottom line that is wasteful of everyone's time, money, and energy. But I don't want to spend time publishing 30 emails. So, if you can do a handful and then perhaps get some others through a witness.
Yeah.
Obviously, I will keep your time running during any publishing that you do, but I will allow you to do a couple of them without a witness.
Okay, so we will likely publish maybe 3 today. Okay, thank you, Aaron.
What's next?
Judge, I guess now, unless the defendants have found something overnight, we still do not have the 2017 review of Kathy Beatty, which would be the one that encompasses the actions of the fall of 2016. And we need to know, once and for all on the record, whether that exists or not. And if it doesn't exist, then we may need to recall the defendant's expert on that point, because his opinions, the court may recall, included a review that apparently does not exist. So they found it?
I believe we did inform counsel last night, but I double-checked with my client's HR department, and the last review for that period ran through October 27, 2016, which is the one that they were handed. Because they changed over systems, the next review did not start until July 1st, 2017, after the incident in question, 2018.
Yeah, there's no written.
Yeah, there's no written review after 10/27, so there is none to provide for the second part. Yes.
So there's no review of employees by the hospital? I mean, that's what I'm hearing you say.
There's no written review of this employee between 10/27/16 and 7/1/17 when the next one.
Are there written reviews of other employees?
I'd have to double check that, Your Honor.
Right, Judge, my understanding in speaking with the hospital is that they had a changeover in system. And because of that, there were no reviews done in October of 2017. They were done in October. In October of 2017, there isn't one. It's not until later that there's one. But I think the point, Judge, is the witness was testifying based on a document that ended in October of 2016. To the extent that the jury or the court or the other counsel is concerned that they were given the impression that there was a review he reviewed after that, we're willing to stipulate to a statement being read to the jury that says the review that was testified to by Mr.
Anderson.
Thank you. That's right, Anderson. Mr. Anderson was a review that ended in October of 2016. He did not review anything post October 2016.
Well, it seems hard to believe that an organization did not conduct reviews. How did the hospital make decisions on whether to give an employee a raise or not a raise? I mean, it would seem to me that an organization would not go more than a year without giving employees raises based on some sort of review. And I know no organization that is of a large, that doesn't keep written documents of performance of it. Maybe small companies where, you know, the owner knows everybody, but
I hear you, Judge. My understanding, but we're going to double check. My understanding from talking to the people back there that do this is that because of some big, huge change, the reviews were all postponed and there was no review done and written performance evaluation, such as what was done before in October of 2017. But let us get clarity on that issue.
when was the next written review? And I'm not just talking about Ms. Beatty, I'm talking about for everybody. at the hospital.
Well, we only focused on the speeding, so let us re-ask with that broader question in mind.
And the question of how did they give raised determinations if you don't have reviews? I mean,
Let us clarify that, please.
who's going to speak on this?
Yes, motion to strike the testimony of Mark Anderson to the extent that it involves opinions that where he based it in part on the 2017 review and/or a jury instruction to that extent in the event that there is not a satisfactory explanation for whether it's.
I want to get more information before we decide what we're going to do.
Yes, sir.
And we will do that.
And just to let you know, you might need to have an HR person come and talk about this, and that might have to be done on short notice, so get somebody on warm standby.
We understand.
Anything else before we bring in the jury?
The only thing I want to say on that, Your Honor, is in regards to the record, we had given defense counsel notice last night that we wanted to recall witness Mr. Anderson, however this comes out. So we'd just like for that proposition to carry over until we get clarity. I don't know if he's flying out of the state. I don't know what he's doing, but we want to reserve the right to recall him depending on where this goes.
I think we've already said that he has to remain subject to being recalled.
Yes, sir.
Yes. Your Honor,
And if you need to sit down, want to stay seated, that's fine too, Mr. Hunter.
that's okay. That's probably better for me to speak up. I have two problems. The next witness is going to be Sally Smith. Number one, I have not spoken to her at all. We may need to have a discussion regarding what she should and should not say. In view of Your Honor's admonitions the other day, which I intend to abide by, but I want to make sure she understands. But on the other hand, I don't wish to have her cross-examined about talking to me when all I'm doing is instructing her about the court's parameters and the court's ruling.
Why don't Mr. Anderson and Mr. Hunter go talk to her jointly? That way, there's not going to be any misunderstanding.
That's fine, and we can, but that brings us to problem two.
Problem two.
In the interest of judicial economy, I can publish a couple of emails. So, I'm sorry.
What's problem two?
Problem two will facilitate what you. I don't know how else to put this, Judge. Siri took her to City Hall instead of here.
I'm sorry?
She went to the wrong place. Siri took her to City Hall instead of here.
She went to the North County Courthouse, or actually,
No, down the street, but she's about 10 or 15 minutes out. That's what I was.
because sometimes when people put it in Google Maps, they take them to a Waffle House off of. You think it's funny? The problem is that happens all the time. To a Waffle House on North 41.
Is it any good?
It's been abandoned.
Well, City Hall's just 15 minutes from here. It's not,
That's
not too far.
That's what she said, Judge. But I mean, the traffic apparently was very bad this morning to start with, and this didn't help matters. So anyway, we could. I think what I'm hearing from co-counsel here is that if you want to bring the jury in, we can publish a couple of things, and she ought to be here by then. We can step out and talk to her.
Is there a deposition we could play?
We're looking at a couple now.
We're close to Hannah being done. I am not trying a third attempt at Malik until plaintiff's counsel has reviewed.
I reviewed.
Did you cross?
I did, and I indicated one or two areas that you might want to look at.
Okay, but it needs to be clipped yet, Judge. I didn't want to have it clipped until plaintiff's counsel had reviewed it and agreed as to what was coming out. So it needs to be fixed, so it's not ready.
So no depositions ready to go.
How long would it take to flip it?
Well, can't answer that question. But more than 5 minutes, I think there's a lot in hospital.
Well, before I lose you, Ms. Crowells, O'Leary Johnson, I ruled on the plaintiff's objections. I don't think I saw defense objections to their designations. I don't know if I missed it or if none are coming or you just haven't had a chance to do it.
I will check on that, Judge, with the team. I also believe that we're ready to send you Dr. Rose. I believe the plaintiff has done their counters and objections. We just need to get you the dep and everything.
Well, if Dr. Sally Smith isn't going to be here for a few minutes, you can publish, but maybe after a few minutes of publishing, we'll have Dr. Mallett's deposition ready to go, and then we can play that.
I'd be fine, Judge. I'm sorry about the delay.
Your Honor, I think the court could give us some guidance. As I understand it, Chapter 39 efforts of Dr. Smith are going to be off limits for this. So it will be solely as to her actions at the hospital insofar as the issue over agency, and I guess that correlates in with any involvement on treatment teams or suggestions of treatments.
Here is the reality. The jury knows that Sally Smith has a role in the dependency court proceeding. And the jury knows that there was an ongoing dependency action. I am fine with, orienting questions as to her role in the dependency. What I don't want to get into is an examination of her 45-page report to come to the conclusion or her recommendation to the dependency court that Beata Kowalski had Munchausen syndrome by proxy. So a few questions to orient the jury about who she is and her background, that's fine.
No objection to that. Mine would be, to put a finer point on it, an instance would be the question over her conversations with Dr. Kirkpatrick, which could go either way. In one way, if she's an agent for the hospital and she had conversations with Dr. Kirkpatrick, and there's evidence in the record from Dr. Kirkpatrick and his memo at the time that he did.
I think I cut most, but not all of that conversation from the deposition designations last night. I think I left in one or two, but cut, I think, the majority of them, if I remember correctly.
Okay, this is for which depot?
Hannah. Oh, you said Kirkpatrick. I apologize. Because there were questions in Dr. Hannah's deposition about discussions with Dr. Sally Smith.
Yes.
I cut a good number of those out, but I left in a few, which those original questions and calls, it does not offend me, and I don't think it gets into Chapter 39, if there's just, hey, did you talk to some of these doctors?
That is exactly what we wanted to ask, because it puts her on notice, obviously, to the extent that she is involved in the care of Maya Kowalski, that she knows she has these other doctors as a resource. There's Dr. Wassenauer, and then there's Dr. Hannah, and there's Dr. Kirkpatrick. And so I just simply want to ask her, did you have these discussions with them? Were you aware of this as of X time? And that's all I really need to do.
Judge, I didn't go that far. I'll make a profit when it's all over with, but I got a transcript of what Your Honor told me day before yesterday, and in figuring out how I'm going to try to do this, I've tried very much to abide by it.
And I appreciate that. The fact that Dr. Smith has talked to a few or a bunch of doctors, that does not, I don't think that's problematic. It's once you start getting into the substance and the prosecution of the dependency court action, that cannot be discussed. So
I will not.
did she have discussions? Yes, but once we get into the substance of those discussions, I think that's where we need to draw the line. Does that
I think so, Joe. I mean,
work with you?
We're going to inevitably touch on the fact she was, as Your Honor pointed out, conducting an investigation, and she's doing this. But our entire point is that we're not talking about that. That's separate track, if you will. So I've tried to design this thing in such a way as to avoid that, and I don't know where the cross is going to go. That's not my thing. But what I've tried to do is focus on her role and lack thereof at the hospital, and her lack thereof with the treatment team, and the fact that, what she did, she was doing as a CPT captain. That's the whole point.
Yeah, and I understand, and if you need to approach, I'm going to let you have approaching, and we can, if there's a specific question, we can deal with it. It's like in a car crash case, when a investigating officer is doing a car crash case, then they switch it over to a DUI investigation, they change hats, and there's a very clear demarcation. We just don't have that in this particular case, and we'll just have to address it.
I think from what I heard, Your Honor, I think I'm okay with if we just proceed. But there will be, on my end at least, there will be like passing reference to what she was doing, but I'm going to be talking about what her role was, not what she was doing.
Perfect. So let's do a couple of publishing of depositions. If Dr. Smith isn't here and Dr. Malik's deposition is ready, we'll do that. If Dr. Smith is here and Mr. Anderson and Mr. Hunter have spoken to her, then we can call Dr. Smith then.
I'm not sure we need to talk to her based on what Your Honor that's what we said.
I suspect it's better if the two of you jointly discuss with her what we just talked about.
Very well.
I can publish 3 emails at 4 or 5 minutes apiece. That'll take 15 minutes, and then hopefully Mr. Anderson and Mr. Hill will be ready.
And if Dr. Sally Smith isn't ready, then hopefully by then the deposition is ready to go.
Yes, Your Honor.
Okay. Anything else before I bring in the jury?
We need to talk to Sally Smith, and then we can take it the rest of it, Judge.
Bring in the jury. Dr. Smith is here.
Okay.
Where's that choice?
Good morning. Please be seated, everyone. I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And has anyone approached you about this case? And have you seen any media accounts about this case since you were last with us? Okay. Mr. Shapiro.
Thank you, Your Honor. We would like to now publish what's been received into evidence as Defendant's Exhibit 3144, email of Beata Kowalski to Beata Kowalski regarding coma day 1, November 18th, 2015.
That should be on your screen. I'm just waiting for all the jurors to be finished before we go to the next one. Does anyone need more time? Okay, more time. I think they need more time. Mr. Shapiro, I think you can go to the next one.
The defense publishes what's in evidence as Defense Exhibit 3145, email from Beata Kowalski to Beata Kowalski, Comity to 11/19/50.
Anyone else need any more time? Mr. Shapiro, you can go to the next one.
The defense publishes Defense Exhibit 3146, email Beata Kowalski to Beata Kowalski, 11/20/50.
Do we need more time? Okay. Well, more time. We need more time. Mr. Shapiro, I think the jury's ready at this point.
I think we're ready to call our next witness.
Mr. Hunter.
Very well, Your Honor. May it please the court, our next witness is Dr. Sally Smith.
The visual control.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Come this way. You can have a seat in the please.
Morning.
Good morning.
Tell us your name, please, ma'am.
Sally Marie Smith.
And what is your occupation?
I'm a pediatrician.
And where do you presently practice your profession?
I'm a partner in a pediatric general practice in St. Petersburg called Fifth Avenue Pediatrics.
And you have several other pediatricians that work with you in that practice?
Yes,
And that's basically a private practice of pediatrics?
it is.
Would you give the jury a brief, I think the jury's heard some of this, but if you give the jury a brief overview of your background and training in your profession, please.
Okay. My undergraduate degree was Bachelor of Science in Biology from Georgetown University in 1980. I went to St. Louis University School of Medicine and graduated in 1984. Pediatrics is a 3-year training, and so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician. And so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Okay. Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had bad injuries. And when I did my, in medical school, I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics, she had me review all of the pediatric deaths from abuse that she'd seen over a period of maybe 10 years leading up to when I was there. And that got me very interested in the idea. And then as a resident, I saw additional children that increased my interest. And then in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation program at Cardinal Glennon Children's Hospital. I worked with them like once a week or close to that, seeing children in their sexual abuse evaluation program.
Did you subsequently undergo additional training in child abuse pediatrics?
So because of when I started this, which was in the late 80s, there wasn't really what's called fellowship training in child abuse pediatrics. So what I ended up learning over the years was mostly through experience. And beginning in 1988, I was the director of a sexual abuse evaluation program in New Brunswick, New Jersey at the Robert Wood Johnson University School of Medicine, and I was a teaching general pediatrician there. And then in 1990, I moved back to Florida, and I actually took a general pediatrics faculty position at All Children's Hospital. And as part of my job, I asked them if I could work with the child protection team. And so from there, I just ended up seeing virtually all the children that have come through All Children's Hospital for the last 32 years who needed evaluations for alleged child abuse and neglect. So I gained my training, if you will, in the trenches, just seeing children, looking things up, reading about it, checking with expert colleagues, learning from, the radiologists, the neurosurgeons, the other people who work with these children down at All Children's, and ended up acquiring a pretty high level of expertise.
Did there come a point in time at which you applied for board certification in child abuse pediatrics?
Yes, so in 2009 was the first year that a board certification was made available for the specialty of child abuse pediatrics. And at that time, as I mentioned, because there wasn't really a fellowship in child abuse pediatrics, which would be 2 or 3 years additional training, the people who were allowed to sit for the exam could also be people who had at least 5 years experience in evaluating children for child abuse, were working in that specialty for at least 20 hours a week, which I qualified for both of those. And also you needed to have essentially a letter sent to the American Board of Pediatrics from someone who was kind of a recognized expert in child abuse, who would sort of vouch for you, that you were a person that should be allowed to take the exam. So I took that exam, I believe in November of 2009. It was in the fall. And then I think early January was notified that I had passed the exam and therefore was board certified in child abuse pediatrics.
Okay. Now, did there come a time in your career at which you became involved with the child protection team for Pinellas County?
Yes, so I worked for All Children's. I'm going to keep leaving out the Johns Hopkins because I've just been using that term for 32 years. But anyway, when I went to All Children's to join the faculty, I started working with the child protection team in Pinellas County. And the hospital basically had an arrangement where they billed the child protection team when I saw cases for them for the hours that I worked, and allowed me to have the time to do that. And so for that 12-year period when I was working for the hospital, I was on campus. And so vast majority of the children who were hospitalized where there were allegations of child abuse and neglect and a medical evaluation was requested, I did those evaluations. So I was a consulting pediatrician for the child protection team during those 12 years. In November of 2002, their medical director left, and they asked me if I would take over as the medical director. So at first I tried to work out a way to keep my job at All Children's and also do that, but it wasn't really very practical. And so I ended up resigning from All Children's at that time and became the medical director for the child protection team. So for Pinellas County, that's about a 20-hour-a-week. I ended up working more like 26, I believe, over time, but it's about a 20-hour-per-week job. And so I did that, and within a few months, I started working at this private practice where I still am.
Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from what was then just All Children's Hospital.
Right.
No Johns Hopkins.
Right.
In 2002, is that right?
Correct.
And at that time, you became the director of the child protection team for Pinellas County. Correct?
Right. The term they use for the physician is the medical director. So I was the medical director.
So, what is a child protection team, and who constitutes it? Who were you working for at that time?
So the child protection teams, Florida has a kind of a model program for the country, and it was set up in the late 70s. I think that All Children's started.
Objection, Your Honor. This is beyond scope. Move to strike.
Sorry?
Sustained.
Can we approach that?
Sure.
Mr. Hunter's going to ask a different question, and the jury will just disregard that last question.
I'm going to fast forward a little bit, if we can, without a history lesson.
Okay, sure.
The CPT. Well, let me back up. We talked about that you resigned from Johns Hopkins from All Children's Hospital in 2002.
Right.
And have you ever worked for them or been employed by All Children since then?
No.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Or Johns Hopkins?
No.
Okay. Without going into the historical details, well, let me lay the predicate this way. When you saw Maya Kowalski in 2016, were you the medical director of the Pinellas County Child Protection Team at that time?
Yes, I was.
Okay. And you had been so since 2002 in one role or another?
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection again, beyond scope.
No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a team psychologist, for example, that's contracted, a team attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida. And so they work side by side, but DCF doesn't run the child protection teams. And so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
Okay. So in any given situation of a child abuse investigation, what is the role of the child protection team and its medical director in pursuing that investigation or facilitating that investigation?
So primarily the role is to provide that medical evaluation, and it kind of varies exactly how much work is required to do that. But also we end up being a go-between with the dependency attorneys, the child protective investigators, the detectives or law enforcement that may be involved in a case, again, to provide that medical expertise to assist everybody in making a good decision for the child. We present information in court on a fairly regular basis and assist the dependency judge or the juries in evaluating the cases for whatever legal action may be needed. And one of my roles, which is also in statute, is to provide education for community medical providers.
Overruled.
So in that role, particularly for a teaching hospital like Johns Hopkins All Children's Hospital, the residents are required to have a certain amount of training in evaluating child abuse and neglect. And so over the years, I've been involved in that element as well to help provide education for the medical students and residents there at the hospital.
Okay. And do your statutory duties as medical director of the CPT, in your understanding, require that you consult with healthcare providers in a situation where a child has been sheltered?
There certainly are scenarios in which that's an important component of what were my responsibilities. Not always, but many times, especially in more complicated cases, the treating physicians at the hospital may need an ability to consult someone who is more expert in child abuse or neglect case for a variety of reasons.
Now, in the fall of 2016, and particularly in September and October of 2016, you've told us that you were the medical director of the Pinellas County Child Protection Team at that time.
Correct.
What other hats did you wear as a pediatrician in the community at that time? So
I had my private practice. At that time, I was working half-time there. Now I'm full-time. And I also, ever since I moved to Pinellas County in 1990, I had active medical staff privileges at All Children's Hospital. I do to this day. And that doesn't mean anything about being employed by the hospital or being somehow under the hospital, but the the medical providers that go in the door there have to have credentialing in order to go in and see patients, communicate with the other physicians, review the medical records and the radiology studies and lab work and all those kinds of things. And so that was essentially another hat where I was active medical staff with the hospital. And then as a community pediatrician, and obviously I'd been there for 12 years, so I was well known to the medical staff members, and they asked me to be a representative on a number of hospital committees over the years as a representative of the community to sort of bring that to the table. So I think at the time in 2016, those were the main additional roles that I had besides being the medical director of the child protection team with regards to All Children's.
Okay. At that time, in the fall of 2016, did you have what we refer to as staff privileges, medical staff privileges at hospitals other than Johns Hopkins All Children's?
Yes, I believe the only one as of 2016 would have been Bayfront Medical Center, which is Orlando St. Pete now or something, where I've had privileges since 2002 to see newborns in the nursery there. I mean, I have staff privileges, but that's what I actually use them for.
Okay, so you would have privileges to practice both at Bayfront Medical Center and at Johns Hopkins All Children's Hospital.
Yes, and in addition to being able to walk in the door and evaluate children as the medical director of the child protection team, in 2016, I still had some patients from my practice that were complicated patients that sometimes I would admit to the hospital and manage their care. That was a different hat. That's my private practice side. That's all been taken over by the hospitalists in recent years, but I used to do that multiple times a year, admit my own patients to the hospital.
Okay. Now, in this particular case, how did it come about that you became involved with Maya Kowalski?
So the main way I became involved was because there was a report concerning child abuse or neglect.
Objection. Scope of that. Active group should report that, unless I get.
Just
Continue, Mr. Hunter.
thank you, Your Honor. Please go. Let me focus this a little bit.
Okay.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Tepa-Sanchez?
Yes, I did.
And at that time, when you received that call, did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. Tepa-Sanchez contacted you regarding concerns that she had?
Yes.
And what did you do tell us very specifically and not at any length, if you would, what you did in response to that phone call.
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to
What?
You can continue, Mr.
Good. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And were you called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect, as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
Now, with a call such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly, yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by the investigators to provide a medical evaluation. And at that time, to my understanding, there was no actual investigation ongoing yet. And Dr. Tepa Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation. So it was a Saturday, as I recall, 1-ish in the afternoon, and we had a little discussion at that time, and then I honestly didn't think about it more, do anything more about it until Monday, when I got that referral where the child protection team was asked to provide a medical evaluation.
So between the time that you spoke with Dr. Tepa Sanchez and looked at the chart briefly, and the time you were advised of an investigation on Monday morning,
as I recall, it was Monday morning, yes.
Did you take any action to render diagnosis, care, or treatment to Maya Kowalski?
None whatsoever.
And so you had a brief telephone conversation, and until you were told there was an investigation, you took no other action to involve yourself in this patient's care?
Correct.
Now, once you were advised of the investigation, did you undertake well, first of all, and I want you to answer this question very narrowly.
Okay.
Were you advised of an investigation and asked to conduct a medical evaluation as the medical director of the child protection team?
Yes.
And is that the point at which you began your investigation of the case?
That's the point at which I began my medical evaluation of the case. I wasn't the investigator. Those are other people. I was providing a medical evaluation for the child protection team to assist those other people.
Okay. And in conducting that investigation, were you acting as a medical staff member of All Children's Hospital, in other words, a pediatrician in consultation, or were you acting as the medical director of the child protection team?
You know, there's a slight overlap because the privileges that I have at the hospital allow me to review their records and enter the building and examine children and things like that. So there was a slight element of my active medical staff credentialing that was in play, but primarily I was acting as the medical director of the child protection team.
Who was conducting the care of Maya Kowalski at that point?
At that point, she was in the pediatric intensive care unit at All Children's, and so the ICU physicians, the pain management team, I'm not sure if there were any other consultants that were involved at that point. Certainly all the nursing staff and the support staff and everything were the ones that were managing her care. In not just this case, but in child abuse cases, I don't really get involved with the management, day-to-day management of the children at all. My role is specifically to do this medical evaluation. And so I focus on that part and not really anything related to, you know, whether the child gets a regular diet or what medications they're on or how often they're getting vital signs or any of that kind of thing.
And is your involvement in the medical evaluation as the CPT medical director part of your, in your understanding, part of your statutory duties as the medical director of the child protection team?
Yes.
With respect to Maya Kowalski, did you ever write a consultation in her chart?
So the physicians that are treating the children that I see down there for a child abuse evaluation obviously are going to be helped if they know all of the medical data related to that potential diagnosis. And so recently there's a different electronic medical record system and it doesn't exist anymore. But at the time that I was involved with this case, what I would routinely do would be to provide my medical report to the treating physicians at the hospital to assist them. And that's okay when they basically ask me if they can have my my report, then I can provide it to them. There was a sort of a super confidential kind of process that was set up so that not, you know, the housekeeping staff couldn't look at these medical records, but a physician who was logged in that manner could see the child protection team report and could, you know, utilize that for either that time they were in the hospital or maybe a subsequent time they were in the hospital. That doesn't really occur the last four or 5 years or so, but that was in place at that time.
But your report would not have been placed into this portion of the chart you're referring to until you actually rendered it, completed it, and signed it much later, correct? Typically
correct, yes.
When you are in private practice, when you're managing a patient, well, let me ask you this question. When you're managing a patient in a hospital, whether it's Bayfront or Johns Hopkins or wherever, and you call for a consultant, a specialty consultant.
Yes.
What typically happens? You get a consult report in the chart?
Right. I mean, I had many years of experience, like as an actual in-hospital person, and that's what's typical. A consult order gets written. In this case, it's different because there's no consult in the All Children's medical record for a child protection team evaluation. That has to go through the child protection team and child protective investigations in the state of Florida. So there's never a consult order for a child abuse evaluation from a hospital physician. What they do is they make a report, or their typically social worker that's involved with the case makes a report to the hotline. That's how it works in Florida. That's how it works at All Children's.
So during the time that Maya Kowalski was at All Children's, did you ever write an order in her chart?
No, I did not.
Did you ever write a progress note in her chart?
No.
Did you from time to time talk with the physicians that were caring for her?
Yes.
But did you see her or round on her on a day-to-day basis?
No, I saw her one time, I believe on October 13th, 2016, and I saw her one time in early November. Probably between 5 and 15 minutes each time. Those were the only times I ever saw her while she was in the hospital.
And what was the purpose of your seeing her those 2 times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the Child Protection Team Medical Director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case. So I went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Did you ever interview Mr. or Mrs. Kowalski?
I took, as part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th, 2016, and the relatively brief interview or history taking with Mr. Kowalski occurred on October 13th.
Okay. Did you ever speak to the 2 of them together?
I did not.
When you spoke with Mrs. Kowalski, first of all, where was it?
So at that time, Maya was still in the pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the child protective investigators and the people in law enforcement that were investigating the case could join me to while I took my medical history. So there, as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Okay. Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team. And that's what I said to her.
And the other folks who were there were either law enforcement or child protection investigators?
Yes. It's possible one of the nurses was in there, but otherwise those were the people that I recall being present.
Okay. Were you wearing a lab coat?
No.
Do you ever wear a lab coat at all, children?
Well, at All Children's, no. I do in my office now since the pandemic, but for 20 years, I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my Johns Hopkins All Children's identification badge to come in the door and to move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear an All Children's badge.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the Child Protection Team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No. As I said, this was a scheduled meeting. Everybody knew exactly what was happening.
Did Mrs. Kowalski know?
Absolutely.
How do you know she knew that?
Objection. Speculation.
Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So she, and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on their badges and their, work-related clothing and things like that. So,
Objection, again, speculation as to what the
overruled, she can say what she saw.
So, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So,
I'll
Okay.
follow up on that. When did you talk with Mr. Kowalski?
so that was on October 13th, and I'm honestly not sure exactly what time.
Okay. And how long did that discussion or meeting last?
I would guess about 10, maybe 15 minutes.
And who was present for that meeting?
The bedside nurse, I'm pretty sure she was still in the ICU that day, and Mr. Kowalski and Maya.
Did you identify yourself to Mr. Kowalski?
Yes, I did.
And how did you identify yourself?
I said, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team.
And did you at any point advise Mr. Kowalski that you were acting on behalf of Johns Hopkins All Children's Hospital?
No.
Were you attired in much the same way as you were when you spoke with Mrs. Kowalski?
I was wearing professional street clothes both times.
Okay. And again, no lab coat?
No. I would have had my badge on both times because I was in the building, but otherwise just professional street clothes.
Now, at the time that you spoke with both Mr. and Mrs. Kowalski, and I think I'm getting the dates right, around the 11th and the 13th of October, respectively, were you aware of any efforts being made to transfer Maya to another institution?
So I would say during that week, I knew that that was being investigated by, I believe, the hospital. I can't tell you exactly what day I knew that, but I definitely knew that there was an effort being made to transfer her to an inpatient intensive rehab facility.
And were you involved in that effort at all?
No.
Were you directing that effort at all?
No.
Were you directing any of the medical care of the patient at that time?
No.
How did you know that was going on?
That's why I'm not sure exactly the time frame. I know that week there was a multidisciplinary staffing that took place with people from the Sarasota County investigators and Child Protection Team and myself. And I believe there was discussion at that meeting. I believe that meeting was on the 13th, but I'm not 100% sure. But there were multiple discussions that I had with the treating physicians at All Children's that they were trying to make that kind of thing happen.
And did you have any understanding about whether there was an effort being made to wean Maya Kowalski's medication or reduce her medication as part of that effort?
I did not really, have any involvement with any of that. I believe at one point later in October, maybe right around now, October of 2016, that I knew that that was happening.
Okay. And did you, once again, learn of that from the physicians directing her care, or did you attempt to direct that care yourself?
I learned that from communication with the attending physician.
Okay. And do you typically follow that as part of your statutory duties as Child Protection Team medical director? In other words, follow the course of the patient's care.
Yes. typically when I've seen a child, and then as I'm writing my report, I kind of go back in the chart, see what's happening, put some of the quote unquote hospital course into my report, and then, reach the conclusion. This was a much more extensive, lengthy process. So at that point, at the end of October, I hadn't, done any report or anything, but I was still in communication with them related to what was happening with the child abuse part of the case.
Okay. Now, let me ask that we put up Trial Exhibit 2123-723 in evidence. And let me ask you to take a look at this, Doctor. It's an email from Kathy Beatty. Do you know who Ms. Beatty is?
Yes, I do.
And did you, in fact, make a request of Ms. Beatty to get together with the treatment team to talk about Maya's upcoming needs in December?
Sorry, I got my stuff in front of the screen. Yes, so I believe at that time I was in communication with the dependency attorneys, and there was a need to...
You can answer that question.
There was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things, and
Let's wait for the next question, Dr. Sellers.
Yes, let's.
Coach Ash.
Members of the jury, you're going to disregard the answer that Dr. Smith was just giving. Mr. Hunter will ask a different question.
Well, let me ask a kind of a bottom line question here first.
Hold on. Can I see the attorneys again? You may continue, Mr. Hunter.
Hey, police court. Thank you, Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this point?
No, I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh, so you wound up not attending this meeting?
It wasn't for me to be there, it was for them to have the discussion.
And you wanted to know what their consensus was. Well, I mean, strike that, never mind. Did there come a point at which you became aware of any pictures or videos being taken of mine?
Yes.
And tell us in general how that came about.
I'm not sure from the standpoint of the treating team at the hospital. From my standpoint, that was related to attempting to have some photo documentation as part of my evaluation and that could be available as part of the investigation.
Was it your understanding, well, did you have any understanding of whether the treatment team desired any such pictures for clinical reasons?
I believe so, but you know, what I can speak to is what I was doing, or my role with it, and my role was related to this attempt for some, in this case, video documentation for the purposes of the investigation.
So was there ever any point during this patient's entire hospitalization at which you were part of the treatment of the team rendering clinical care to Maya Kowalski?
No.
And did you ever hold yourself out as such
No.
to the parents?
No.
That's all I have for now, Your Honor.
Mr. Anderson.
Dr. Smith, how many times have you testified in court?
Probably over 300.
And how often have you met with defense counsel?
Well, pretty often, because usually there's a deposition in cases where I'm testifying. Oh, this one? 0.
You did not meet with Mr. Hunter
I did not.
yesterday? Did you have phone conversations with him?
I did not.
And not an email?
No.
In the week before, did you?
No.
How did you know to come here today?
Because my attorney from Suncoast Center's insurance company told me to.
Are you still doing what you were doing in 2016 to this day?
I'm a pediatrician. I resigned from the child protection team last July.
You wear several hats, Fifth Avenue Pediatrics, private pediatric practice, right?
Yes.
And then back in 2016, you were more or less director of the Johns Hopkins Child Abuse Team, right?
They don't have a team. They had residents that came to our clinic to learn about child abuse pediatrics once or twice during their second year of training. and I was the designated director for that rotation for them. And if we had maybe 5 or so over the 20 years I was the medical director, residents who came and worked with us for a month, so I would be the person that would be supervising them for those rotations.
All right, so you're in charge of the residency and
For those things.
And so you were considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins insofar as the...
Sustained.
Have you ever heard that you were referred to as a go-to by the doctors there?
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now, you said, though, that you weren't a part of the treatment team. Did I understand your testimony?
I was not.
Here?
Correct.
Can we bring up Exhibit 1002-0005? Next to last paragraph, bottom sentence.
I'm sorry. Oh, okay. I see at the very top.
The last,
barely see the discharge summary note. Okay.
All right.
Okay.
Now, you weren't and didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist.
Certainly not.
You were not a pain specialist.
No.
You were not an anesthesiologist.
No.
You were not involved in rehabilitation medicine.
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and third sentence. Nope. Above. No. This is at 0006, and I'm looking for the. All right. So, Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
Well, getting Maya Kowalski off of all of her medications is not part of your job with CPT, is it?
Well, so that was...
Isn't it? Yes or no?
Excuse me, Your Honor.
As soon as she says yes or no to whether it was or was not part of her
Why
job.
don't you answer the specific question? If you need to explain, you can start explaining.
I'm sorry, could you just state the question again one time?
Sure. Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications was not part of your job description at Child Protection, is it? Or was it?
The
Is that
part
yes
about...
or no?
Yes, but I have to explain.
Yes, it's part of your job to do that, to manage Maya Kowalski's medications.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
I guess it's sort of threading the needle. I wasn't writing any orders. I didn't tell them which medications to stop or wean or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications. And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down, number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
Yeah, I believe the legal term is
text from you? To
Yes, it
Paula
is.
Dees?
Yes, it is.
The Paula Dees that testified, well, you wouldn't know. Probably already, but is that as many meds, it just says meds here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team, as part of the treatment team, to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it, and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
So again,
I'm just asking whether he did or didn't.
well, clearly, I believe I had some discussion with Dr. Carroll, who this is, she's one of the hospitalists, and so that's her note. So clearly we had some discussion about documenting that certain lab tests presumably were now normal that had been abnormal, but I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes.
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
Yes.
That you had done an extensive chart review, right?
Yes.
And you were making recommendations regarding lab tests, right?
I was, from this standpoint.
And you were making observations of whether they were abnormal. Is that right?
I knew she had abnormal tests that I had seen in all of these medical records that I reviewed, but I don't. I mean, I'd have to look up and see. I don't really recall if these lab tests done in mid-November had any abnormalities.
A CBC, a CMP, a UA, a lipid panel ordered. Lipid panel is to check her cholesterol level, is it not?
Right. At one time, hers was 363, I believe, quite elevated at various points.
So now you're in charge of her cholesterol as well? Is that right?
The lab tests had certain abnormalities that, based on my record review, I suspected were related to medications and potential toxicity. And so in evaluating the medical child abuse, one of the things we're trying to assess is if harm has been done, and hopefully it's reversible. So that was the thought process, the mindset that I was approaching this discussion with Dr. Carroll.
You're not a pharmacologist, are you?
I'm not.
Also, an IG profile. What's an IG profile?
Immunoglobulin.
And an IgE?
So that's a specific one of the immunoglobulins. There are A, G, M, and E.
And a RAS test to check and see if she had allergies?
Correct. That was one of the things in the medical records that was said to cause some of her symptoms.
Are you an endocrinologist or an allergy expert?
I see a lot of children with endocrinological and allergy problems in my general practice, and I saw a lot of them in my role at All Children's for 12 years, but I have neither board certified specialty.
You don't have a specialty in either one of those, do you?
I just said that, right?
And you were worried about her dog dander allergy, right?
Yes.
And dog dander allergy is clearly part of Munchausen by proxy, right?
It is.
Yes.
May continue.
No, I was just sustaining that objection.
All right. And on December 13th, 2016, I realize you might not recognize a lot of the days, but to put it in context, by December 13th, 2016, now Maya had been at the hospital for what, 1, 2, almost 3 months? 2 months.
October 17th to December 13th would be a little over 2 months, right?
Right. And you were still on the team, were you not?
I was still the medical director of the child protection team.
Well, you were part of the treatment team, were you not?
I was not.
1001-0200. Did you or did you not confer with the team regarding creating a behavior chart? Bottom last 2 sentences. Highlight, please.
So,
Did you or did you not become involved in creating a behavior chart for Maya Kowalski?
looking at this note, I think I misspoke earlier. The way that I didn't see any of these ahead of time. But the way the email was written, it was that they should meet, but it looks like I probably did actually attend that team meeting. And so it looks like these were the things that were discussed related to coming up with this list of things that would potentially help the court that was involved at the time.
You just said you hadn't seen these prior to this. Why would it be important for you to see all of these notes in the medical record prior to this if all you're here to do is tell the truth about what you know?
Objection, Your Honor. Argumentative.
Sustained.
And then you had the pain team on documenting pain weekly. Is that right?
Well, I mean, it speaks for itself. These were the things that they said we talked about. I don't have an independent recollection of this specific meeting. And certainly I've been reviewing a lot of stuff the last couple of weeks, but I did not see this nor Kathy Beatty's email ahead of time. So I'm just going by what I'm seeing right here at the moment.
Okay, so then you were involved then in changing the room?
Yeah, I'm not really sure what that's in reference to.
Was that changing the room to the 48-hour room, the surveillance room?
No, that was back in November. So
I'm sorry. Go ahead.
I was going to say I'm not sure what this is talking about.
Okay. So were you aware that during that 48 hours, Maya Kowalski was forced to urinate and defecate on herself because she could not get over to the commode?
Objection, argumentative, and facts on evidence.
Overruled. She can answer.
No.
Were you part of the decision to put the commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of any decisions to make sure that the nurses moved slowly so that she would be forced to have the decision of either urinating on herself or worse, or, I guess, calling and waiting?
No, I had no idea about that or what you're talking about.
Would that be child abuse?
I think that would be a stretch.
Argumentative.
Sustained.
All right. So, if we go back then, as you were talking about, that was in December. If we go back then into October, were you again part of the treatment team with Dr. Hart, Dr. Elliott, and Dr. Dees?
No.
1001-0429, please. Right above the line there, please, and that right there. Now, please take a look at it, read it if you can.
Yes, I have.
All right. And here, Dr. Dees states that she spoke to you along with Dr. Hart and Dr. Elliott. Do you see that?
Yes, I'm pretty sure this is in reference to a meeting that we had on this, I think it was that day, on October 18th. One of the things that's recommended in evaluating medical child abuse is to meet with the treating physicians and discuss what their observations are and everything so that I can then convey that in my report that I wasn't just sort of like out there rogue making this diagnosis, that there were other physicians with some of these other areas of expertise that I had discussed the case with and had the opportunity to hear their expert opinions. So Dr. Hart was the rehab physician, Dr. Elliott was the anesthesiologist, and Dr. Dees looks like would have been the hospitalist that was the general pediatrician taking care of her at that time. So that was the purpose of that meeting.
Well, it says here that the purpose, the first one, was continue with the current plan, right?
I don't think that's what it says. I think those are two separate things.
Right. Well, wouldn't a treatment team be the team deciding about keeping with the current plan?
Yes, and I think that's what Dr. Dees was referencing. So this is her brief note at the end of the pediatric residence note, and they will put in a few sentences, sometimes more, and so I think there are three separate sentences here where two separate sentences that she added to, convey what her plan was for that day as the attending physician.
All right, I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis.
Not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning. So the 9th. Yes.
So what were you doing accessing Maya Kowalski's private confidential medical records on the 8th if you were just part of the child protection team and there was no investigation?
I was doing so under HIPAA's what's called TPO exception to the confidentiality guidelines, which allows for...
Objection, move to strike for legal conclusion as to what the statute says.
I'm going to sustain the objection. Mr. Anderson, you can re-ask the question, and we'll get to a break in just a couple of minutes. Mr. Anderson, within 5 minutes, we need to take a break.
So true or false, you accessed Maya Kowalski's medical records on the 8th.
I did.
Prior to that, you did not contact Jack or Beata Kowalski. True or false?
Correct.
Is it not true that you often walk in after?
Mr. Anderson, if you're going to a different,
I am.
then why don't we take the break now? Members of the jury, do not discuss this case amongst yourself. Do not do the investigation and receive more information. Let's try to keep it to a 10-minute break.
All rise. Jurors exiting.
So we'll get that to
Great. And then how about O'Leary Johnson?
Oh, I'm sorry. I meant O'Leary Johnson. I said those. I meant O'Leary Johnson.
Great. So there's nothing more with O'Leary Johnson that I have to do.
That's correct.
Do we know where Mr. Hunter is? Or?
You want me to find him, John?
I'll just give another minute or two.
It was mine that made it.
Yeah, I wanted to ask the court if, while the jury's out, could we?
Well, Mr. Hunter's not here.
Yes, sir.
Is this a conversation that we need Mr. Hunter for?
I only wanted to mark what the doctor brought in.
Or why don't we wait for Mr. Hunter at that?
Yes, sir.
And speaking of Mr. Hunter. Let me ask the lawyers this. There's been several references to Dr. Carroll and Ms. Leslie Carroll. Do we need to say anything to the jury that Dr. Leslie Carroll and I have no relationship, or just leave it alone?
I think they're clueless about that.
It's up to you, Judge. I mean, I don't.
I'm sorry? And as a reminder, my brother is a Dr. Carroll.
Yes.
And so,
It might be a good idea to say something just for that reason. Yeah, because they may have heard Dr. Carroll.
Okay.
I don't think it hurts.
so I'll just make that mention. Now, Mr. Anderson, there was another issue you wished to address with when Mr. Hunter was here.
Oh, yes. Thank you, Judge. All I wanted to do was mark for identification what Dr. Smith brought in with her to testify with.
You mean all those notebooks?
Well, that's a good point. And let's see what you're talking about here.
Let's just talk practical from the clerk's perspective. If Dr. Sally Smith has only looked at like 2 pages this whole time,
Yes, I see the court's.
I have no, I mean, you mark that.
Yeah, I just think that the binder she has open right now is the only thing I would want. That's the only thing I've seen come out of it is this one binder that is before her right now.
well, I don't think she's looked through the binder. I think she's only looked at the couple pages in her hand, so.
I don't have any issue with her looking at her, with marking what she has looked at. But that should be it.
I always thought when they brought stuff to the stand, you could explore whatever they brought.
Well, if she's not looking at it, and it's just more or less a prop, if you will, at this point, I just don't want to have 5 or 6 5-inch notebooks having to be given to the clerk who already has so many notebooks.
She's got quite enough notebooks. Yes, that's what I was just suggesting. Only this one that she has got open right now and referred to. I have not been able to see how many pages, what she's referred to, but I do know that it appears to only be one notebook.
Dr. Smith, why don't you close the
Sure.
black notebook and only keep out what you actually looked at, which is in your left hand.
Okay,
Okay.
good.
So, just as a reminder, if Dr. Smith is going to look at any of those items, then we'll probably mark that. But just to mark 5 binders, mark them, it's not good.
Understood.
I don't know if it's proper, but all of these are shared documents that are bait stamped, except for a couple of folders with references. And as you have stated, I haven't touched them. So
And unless and until you have to look at them, let's not worry about it, because I don't want to spend the time having the lawyers go through to check to make sure that there isn't a sheet of paper that isn't in evidence or not in evidence.
Right.
That would take forever and doesn't help us along.
right.
I think what she's got is her report material.
Exactly. I didn't realize I wasn't going to need it.
So I guess the moral of the story is, unless you absolutely need to look at one of those items in your binder, let's not go there, because then
You got it.
adding tonnage to the number of items the clerk has to keep track of.
I don't really want to kill those trees.
Are we ready to bring in the jury? Mr. Hunter, are you ready for the jury? Let's bring them in. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Have you seen any media accounts since you were last with us? Has anyone approached you about this case since you were last with us? Mr. Anderson, you may continue. Before I did it, there's been a couple of references to Dr. Leslie Carroll. Obviously, my last name is Carroll. There's no family relationship between Dr. Leslie Carroll and myself.
Subject to redirect, plaintiff yields to the various questions.
Well, it goes back to Mr. Hunter now.
Please go ahead. Counsel asked you about your access to the medical records when Dr. Tepa Sanchez called you.
Yes.
Was that as a result of your being asked to consult on a case by a fellow medical staff member?
Correct.
Is that customary, typical?
Yes, and
Objection, foundation, precedent for that.
Well, the answer, yes, remains.
Your duties as the medical director of the Child Protection Team, the CPT, if we can
yes,
use that, the shorthand folks usually use.
that's the usual. Yes.
Okay. Is part of your, do you understand part of your statutory duties with the CPT to follow patients who are sheltered under a child abuse investigation?
My understanding and my responsibility is to provide whatever assistance is requested from the investigators, law enforcement, and attorneys that are involved in the case. So I think I'll leave it there.
Okay. And I think I better leave it there. Have we ever spoken?
I believe, I might be wrong, I believe you were at one of my 5 depositions, but other than that, I knew of you when I worked at the hospital, but otherwise, no, my recollection, no.
Have we ever discussed this case?
No,
Have you ever discussed this case with anyone from my office?
no.
Nothing further, Your Honor.
Mr. Anderson, anything further?
No, Your Honor.
Members of the jury. given the number of questions, members of the jury, I'm just going to ask you to step out. Please do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
All rise. Jurors exited.
Okay, Dr. Presence of the jury on okay. Have you had a conversation with a nurse, Bonnie Rice from Tampa General Hospital?
Back in the time of this case, yes.
When was that conversation, to the best of your recollection? And a month and a year is fine for purposes of this question.
I would say October into November, late October, early November 2016.
Was there any conversations, to the best of your recollection, between you and Bonnie Rice in calendar year 2015 about Maya Kowalski?
No.
Okay. I'm going to ask you those two questions first, and then I'm going to ask you the rest of the jury questions.
Okay.
Let's bring in the jury.
Yes, sir.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
That you haven't seen any media reports of this case. Is that correct?
Correct.
No one approached you. Is that correct? Outside of Dr. Smith's presence, I went through the jury's questions. I'm going to be able to ask a good number of them, but not all of them. Dr. Smith, have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital in connection with Maya Kowalski?
She's a nurse practitioner, but yes.
When approximately was that conversation?
I'm pretty sure it was in late October, early November of 2016.
Have you had any conversations with nurse practitioner Rice in calendar year 2015 with respect to Maya Kowalski?
No.
Next question. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline?
It's an unusual situation, and because of the way that the whole system is set up in Florida and they have to file a report for me to do a medical evaluation, sometimes they're not sure what to do. And so in those occasional situations, I'm going to say once or twice a year, a doctor from All Children's would call me to ask me a question about the case that they were involved in and request my expertise related to the child abuse and neglect question that they had.
Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
I'm sorry, can you?
Sure. Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
The only situation would be if there potentially wasn't really enough evidence or whatever to justify a report. So otherwise, no, I mean, typically the report gets made before I, as an expert, would be involved. Almost all the time.
How would CPT normally access the medical records?
So I always would access them through my remote access that's granted as a member of the active medical staff. If it was a child protection team, say from Sarasota County, that the person didn't have privileges at All Children's, then what they would have to do would be to, submit a request for the records to the hospital to obtain those records.
Does the county child protection team have access to medical records normally without privileges?
only because, well, not like I do with it's an electronic access. Another team or somebody besides me would have to make that request. And there's statutory language that requires the hospital to provide those records in the furtherance of the investigation. So they can get them, but they can't just log in and see them as easily as I can.
Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment?
I'm pretty sure that is correct. So mine's easy because they're just the one hospital. Other teams, like say for example in Miami, I think the medical director probably has to have privileges at Jackson Memorial and Miami Children's in order to go in and see the child, but I'm honestly not sure because it's not my situation. So I don't know exactly what the rule is with that. I think probably they have to have privileges, but I'm not sure.
So if yes, do the privileges grant access to the patient's medical records?
Yes. So as part of our credentialing, we get re-credentialed every 2 years. We have to do like certain, HIPAA training about medical records. There are rules about which ones you can and can't access. It's pretty closely watched and monitored. And so, I can do that in my role as the medical director of the child protection team, and on these occasional situations where they call me separately because they're not sure what to do and need child abuse pediatrician expertise, I can do it in that role as a member of the medical staff.
Is it standard for a child protection team physician to offer recommendation to a child's treating physician in a suspected child abuse case?
With regards to potentially certain tests or certain needs of the court, yes. So for example, if I'm seeing a child that has a bunch of injuries and they need a follow-up brain scan, I can make that recommendation to the team. Could you please do a brain scan on such and such date? And, typically they're going to do what I ask them to do in terms of that because it's something I need for the purposes of the investigation and to assist all the various people involved to make a good decision in the case. So I think that answers probably.
Who made the referral to your child protection team for the evaluation?
The child protective investigator called our person called a case coordinator that was on call or was the designated person to receive what they call intakes. So when there's an investigation that's been initiated, particularly in a case like this where there's a major medical component, then the child protective investigator calls the child protection team, and one of these case coordinators, or we actually had a person that they called an intake coordinator, takes the information, kind of reviews everything, and then that person would contact me and say, Dr. Smith, we need you to go down and see such and such child at the hospital.
When you told Dr. Dees to get Maya off as many meds as possible, did you know that was already in progress prior to telling Dr. Dees to do so?
I did not.
Do you still have medical privileges at Johns Hopkins All Children's Hospital?
Yes, I still have active medical staff privileges there.
Members of the jury, that is all the questions that I'm going to be able to ask. So, Mr. Hunter, you now have the floor, sir.
Morning again. Could I have trial exhibit 2408-1739 in evidence?
What's the number again? 2408.
At 2408, what is that?
What's the second one?
Can you take that down, please?
$2408-1739.
Is this 11?
Yeah.
Yes.
Me- Okay, you lost me again. Wait a minute. This is for your edification, Doctor, this is an email from Beata Kowalski dated 12 October 2016. And I'm going to ask that you go to page 1739, the following page. And then the midway through the second full paragraph on that page, there's a indications Tuesday 10/11 evening. I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this case. Would that have been about the time that you spoke with Mrs. Kowalski, the author of this email?
Yes, that's exactly what, and she says an hour and a half. So just like I said earlier, that was that evening that I came down and talked with her.
Okay. There was reference to the EEG video that was taken of this patient.
Yes.
Have you ever reviewed it?
I don't believe so. It's possible at the time I looked at a few minutes of it, but I don't think so.
Were you aware of any indication on that video of Maya Kowalski defecating or urinating upon herself?
I had no idea if that was true or not, frankly.
Did you ever hear any indication of that and
No.
suggestion of that in real time?
No.
That's all I have. Thank you.
Mr. Anderson.
Yes, counsel. Yes, clarification. I'll ask my question.
So no questions?
Yeah.
And Mr. Hunter, do you have any questions?
No, sir, Your Honor.
Do the jury have any further questions? Seeing none. Okay, members of the jury, I'm going to ask that you be back at 1:45, so just a couple extra minutes beyond our normal lunchtime. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. See you at 1:45. All rise. The jury's out of our presence. Dr. Smith, there's a couple things we needed to do before we were able to break for lunch. So, Mr. Hunter, you have the floor.
Thank you, Your Honor. Mr. Brown, just clean copies of the reports here.
We're doing a proffer, just so you understand.
Okay.
Oh, Madam Court Reporter, if you could mark this transcript as the proffer.
Thank you, Your Honor. Dr. Smith, this is a proffer for a potential appellate record, and what I'm going to do is ask you some kind of conclusory questions and some summary questions to avoid you're having to sit here for a long afternoon, and all of us the same way.
Okay.
In the process of your investigation of the Maya Kowalski case after it was referred to you, did you conduct an investigation? Did you gather some medical records?
I did a medical evaluation, including gathering a lot of medical records, yes.
Okay. And did you, in fact, promulgate two different reports
Yes.
regarding that? One was a preliminary report in October of 2016.
October 13th, correct.
Okay. And the other was one signed December 2nd, 2016.
Correct.
Do those reports both indicate the results of your investigation and review to that date?
Yes.
Okay. And in connection with your report and your investigation, did you obtain certain medical records regarding Maya Kowalski?
Yes.
And does your report, does the report you signed December 2nd, 2016, fairly and accurately reflect the records that you gathered and then reviewed for your report?
Up until that time, yes.
Okay. And then were there subsequent records you reviewed after that, after you received after that date?
Yes.
Okay. And does your report first of October, I think you said 13th, 2016?
Correct. Yes.
Does it fairly and accurately reflect your conclusions up to that date?
Yes.
Okay. And that would, if we were to walk through that report and what it was based upon, would your indication be that it contained and fairly reflected the outcome and your conclusions of your investigation up to October 13th, 2016?
Yes.
And would it also reflect what you advise up to the conclusions and facts of which you advised the court, the dependency court, as of that date?
Yes.
Okay. And I'm going to show you what we're going to mark as whatever the court clerk tells me we're going to mark it as.
What's the next in the series for the defendants?
3328.
ID?
For ID, it's not coming into evidence.
Correct. This is 3328 for identification. Let me just ask you, is that a true and correct copy of your report of October 13th, 2016?
Yes.
Can you hand that to me? Are you finished with it, Mr.
Yes, sir.
Hunter? Madam Clerk, it's two-sided, so just be careful.
And then after you rendered that report of 2006, these are new lips, I'm sorry, October 13th, 2016, after you rendered that report, did you continue an investigation as reflected in the report that you signed on December 2nd, 2016?
I continued my medical evaluation up to that point in December and gathered lots of additional records beyond what I had on October 13th, yes.
Okay. And I have a badly marked up copy of what I'm going to ask be marked for identification as defense exhibit.
Is there already a specific exhibit number on that? Down at the bottom, Mr. Hunter, first page, look at the first page.
December or the October?
December.
December is 3045. 146.
The answer to your question, my copy doesn't, but I trust Mr.
Mr. Hughes, will you stand up and let the clerk know what defense numbers are the two reports that have been previously marked?
So the first report is in October 13, 2016 preliminary report, and it is defense exhibit number 3044.
For ID, it's not in, it's just ID.
Just that for identification purposes. For identification purposes, Sally Smith's December 5th, 2016 report is defense exhibits number 3045, and that's pages 1 through 46, and it's currently being printed.
Can't we just put the first page
That's
up
fine.
if you want?
That's fine. I apologize for that.
No, no worries. Thank you, Mr. Hughes.
And to the clerk for attempting to gum up the works one more time. Does your December 2nd, 2016 report, Defense Exhibit 3045, does it also reflect your opinions and conclusions as of that date regarding your investigation?
Regarding my medical evaluation, yes.
Okay. And just if you would briefly tell the court what your opinions were regarding this matter as reflected in that report.
As reflected in that report, it was my conclusion that there was what we call positive findings for medical child abuse, and that the medical record review and the history taking and that kind of thing that I had reviewed provided very strong evidence to support that conclusion.
Was there any conclusion, and is that the conclusion of medical child abuse would colloquially be known as Munchausen by proxy?
Yes, and I believe it's even in the what we call the impression. That was my conclusion in the report. I put in parentheses Munchausen syndrome by proxy because that's kind of a well-known term for this situation.
Okay. And did you reach any conclusion regarding conversion disorder?
Yes.
And what was that?
It was my opinion based on all of the observations of the various medical staff and team and staff members, et cetera, as well as based on multiple other physicians' reports that I had reviewed that she had a conversion disorder. It's actually called a functional neurological disorder now, but at that time it was called a conversion disorder.
When you say she, you refer to Maya Kowalski?
Maya Kowalski, yes.
In reaching the conclusions and opinions you just expressed to us, how many pages of medical records did you review?
I don't know exactly as I sit here, but well over 2,000.
Okay. And I said you brought with you today a stack of 3, 4, and 5 inch binders that is on the table in front of you. Are those at least some of the records you reviewed?
Those are all of the medical records that I printed. So there are some that I reviewed in the electronic medical record from Johns Hopkins All Children's Hospital that I don't have copies of. But everything that I had a copy of in terms of all her medical records going back to actually her, first visit to the pediatrician up in Chicago is in those binders.
Okay. And did the material you reviewed also include certain online WordPress blogs that had been created by Beata Kowalski?
Yes.
I believe that's all I have, Your Honor.
Mr. Anderson, do you have anything in proffer?
Dr. Smith, before, or let's say, right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation, because that's the whole point of the evaluation and gathering all the records. The problem in these cases is that the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me, because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Do you not understand the importance of putting both sides of the story in your report?
The both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed. So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
Dr. Smith, you know there wasn't a single child psychologist or child psychiatrist that diagnosed what you were claiming. You're aware of that, right?
That's also irrelevant.
So you are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but you're not.
That's a proper. You can answer, Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agrees with you.
Well, that wasn't their job to write in the report whether there's medical child abuse. So that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know. Honestly, I'd have to look back to see if they ever documented that as one of their diagnoses. But that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. So, you know, the court has every ability to pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then, you know, the court makes that decision based on the evidence that they receive. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah. So you did not put in any of the conclusions or any of the data from Eagle's Wings and those therapists and psychologists that saw the Kowalskis, did you?
There was a licensed clinical social work intern who saw Maya and her family at Eagle's Wings, and I don't honestly know where that was in the pile of records when I was writing up my report. I kept writing part of the report, having to do other things, writing part of the report, having to do other things, and I inadvertently did not include that in my report.
Well, you did research it enough to realize that Rebecca Johnson had a master's degree and over 20 years of experience as a therapist at Eagle's Wings. Did you not?
Well, the question really in terms of my part
I'm
is
just
whether
asking if you knew that or not, ma'am.
I knew I'd have to look and see exactly what her credentials were. I'd certainly, defer to you if you're reading her credentials off. But it's irrelevant unless she did the whole thing I did, looking at all these medical records and has expertise in medical child abuse, for her to be able to say one way or the other if there was child abuse or not.
Okay, look, did anybody agree with your assessment that there was no CRPS?
Yes, I believe they did.
Who?
I believe that there were multiple people on the hospitalist team that didn't think she had it, and I believe that although there was probably some question about whether she might have some sort of amplified pain disorder, the pain management team didn't think she had CRPS.
Well, amazingly enough, we did have Dr. Elliott in here to testify, and he never said that she did not have it. None of the doctors so far testified, A, that they were experts in CRPS, or B, that she did not have it. Are you aware of that?
No, I'm not. I wasn't supposed to watch any of the testimony, so I have no idea what people talk
gather
about.
that. From your investigation, though, at the time, did it come to your attention? Nowhere in any of the records did anyone who had any expertise in this, that is a pain management doctor, a neurologist, or an anesthesiologist, ever agree with your assessment that there was no CRPS?
I think I just answered that. Yes, I believe there were people that had the same opinion.
Okay. What did you check with Dr. Spiegel, a board-certified neurologist that treated Maya and confirmed CRPS?
Objection to assumes facts not in evidence.
Go ahead and answer.
Dr. Spiegel had this 10-year-old child do hyperbaric oxygen treatment, I believe, on 40 occasions in a row, when she also got ketamine on some of the same days. So I wasn't terribly worried about whether he thought or did not think that she had CRPS.
Because you'd already decided in your mind that a board-certified pediatrician with his years of experience was not qualified to render an opinion on that. Is that right?
Objection misrepresents the credentials, and I ask for comment on another Crumville no witness.
Go ahead and answer.
I'm sorry.
Dr. Barr,
Yeah.
a board-certified neurologist, he testified and confirmed CRPS. Did you put that in your report?
I don't know that I specifically said that he said that diagnosis. I think, as I recall, without going into the stack, that I did say in the history that Dr. Kirkpatrick had diagnosed her with that. Those people might have had that opinion. I don't think, based on my review of the CRPS literature and discussions with physicians since then, and in the context of all the evidence that there was of medical child abuse, that Dr. Barr's opinion, if that was his, that she had CRPS, was reliable.
Okay, so now Dr. Spiegel is not reliable, and he's a neurologist. At least will you agree that neurology and anesthesiology are the two areas that are most involved in the investigation of complex regional pain syndrome?
I imagine those are people that typically evaluate and treat patients with complex regional pain syndrome, sure, but not all neurologists and pain management or not all neurologists or anesthesiologists are, if you will, created equally. There are some who practice at a very high level, and when I, having reviewed medical records from all kinds of providers all over the state and even other parts of the country for 35 years, read through information and see all the supporting information that they have and compare that with other information that I gather in my medical record review, I can assess whether the person that, made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, a anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, he did a diagnosis of CRPS in your report either, did you?
I believe in the history I made reference to that. I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a child, a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs, and there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he had made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr. Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that. So I didn't find him reliable from what I saw.
All right, so if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board-certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case. And they present all the information, and then the judge tries to decide, whose information is more reliable.
Here, under oath, are you telling us, are you an investigator or are you a prosecutor?
I am
of
neither.
The information?
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson,
I got it.
Any very wide latitude.
I'm done.
You're finished?
Yeah.
Okay. Mr. Hunter, anything further in proffer?
Very briefly, Russ. When you spoke with Dr. Kirkpatrick and he warned you all, did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016, correct?
Correct.
And all those hospitalizations with all those specialists that saw this child, did you see any of them suggest that CRPS was the diagnosis?
No, and multiple were experts in complex regional pain syndrome.
Thank you.
Is the proffer complete?
Yes, sir. Yes.
Okay, Madam Court Reporter, note that the proffer is now closed. Dr. Sally Smith, you had looked at a little report during your testimony. Can you hand that to
Yes.
me? I'm going to hand it to the
You can keep it if you want.
Okay, I'm going to hand it to the clerk. Let's mark it as whatever the next number for plaintiff for ID purposes. And just tell us what that number is.
2804.
So the report that Dr. Smith looked at during her testimony in front of the jury is ID'd as 2804. It's not in evidence.
I'm sorry, I think you said in front of the jury, I think you meant not.
No, earlier during her testimony, she had pulled out a report, and that is what we just identified. Now, does Dr. Sally Smith, is she released or does she need to remain under subpoena?
She's released by plaintiff.
Released, Your Honor. You can watch them.
If you are released, you are no longer subject to the rule of sequestration.
Okay.
Thank you.
Thank you.
Okay, let's be back here, everybody, at 1:30. I will try to review Mr. Anderson's edits to the jury instruction. If you could let Mr. Altenburn and Mr. Elegant know that I'm going to try to address it at 1:30.
I expect you just told them.
Well, I'm just letting you know what my plan is. There's Mr. Elegant. There's Mr. Altenburn. Let's talk about the dependency court order instruction. I've now had a chance to review Mr. Anderson's proposed edits. I didn't know if Mr. Elegant or Mr. Anderson wanted to say anything on them.
Your Honor, briefly, I would defer to Mr. Anderson on the details. It was a continued attempt to make these a little less mind-numbing, simplify them down to something more important, and make sure they had some more balance.
Your Honor, what I did was go back, review the prior order the court had drafted, and compare the orders themselves, and then reviewed as much of the notes as I possibly could on what transpired then as testified to now. And the goal was to try to reduce down to the bare essence those portions of the orders that were pertinent to what the jury is being asked to do here. The idea being that the simpler the orders are, this order is, and the simpler the quote rules are, the less questions we're going to get. This is a very intelligent jury that asks a ton of questions. My concern was that if we give them too much or virtually anything that isn't explained and suited to what they're doing, we're just going to have we're going to spend a lot of time answering questions when we really need to be concluding the case. So the idea here, going through the October 14th order, and this is not perfect by any means. Obviously, you'll see there's a typo and a word or two left out here. But the goal was at the beginning and the end to put in a caveat that the court has, without going into great detail, but that the court has determined the following causes of action are not subject to the immunity. And I think that probably the top of the page on page 2 there needs to be a little stronger than what I've got. And then you'll note at the very end, on page 8 of 8, I've got the same warning. So I wanted to begin and end with the warning, the first one being pretty basic, and the second one being more in line with what I thought what had been agreed to with everyone. And then we go through the October 14th order as to the people involved, the November 10th order as to the people involved. There, in the November 10th order, if you look at page 5 of 8 under other relevant requirements in the bottom, it says that the November 10 order allowed Maya Kowalski to have religious artifacts. A sentence that I did not put in there, but I think should be put in there, are words to the effect, but there was no prohibition on her having religious artifacts before this order. The reason being that by simply stating there's an order, in the perception now allowing religious artifacts, the jury might get the idea that prior to this, they were prohibited somehow. And so there had to be a court order for her to have them. And that wasn't the situation. She was allowed to have them under their patient's rights. And the order was really clarifying some problems that had arisen. Then on page 6 of 8, I thought I had deleted this. Apparently I didn't. The December 9, 2016 order, as I read it, really does not affect anything that we're talking about here because it has to do with a birthday and who gets to go to the birthday. And again, things like that, while technically if we're going to be complete with all the orders, it goes in it, still, I believe that the less things like that are in this, and the more we focus the jurors onto the specifics of the orders that, for lack of a better term, count, the more efficient this will be. On the December 16th order, I have been wondering about the statement about the dependency court allowing Johns Hopkins to supervise the video calls. His medical staff could suspend those calls only insofar as, again, I don't know, in my review of the original order, it did not have the language attendant to that sentence and that portion of the order. But clearly, based on the other orders, Johns Hopkins was always subject to its own internal rules and regulations. And my concern here is that the jury has heard a lot about the patient's rights, statement of rights incorporated into the same packet that has the release the defense wants to argue in favor of. And it clearly was part of the agreement between the parties and part of their website and part of this case. And so I wanted to be able to include in this something to the effect of, according to its rules and regulations, so on and so forth. So that change would go right before this was a change from the November 10 order. I have not put it in yet, but I think it would be appropriate to do that. Although, again, it wasn't specific to this part of the order, but it's specific to virtually every other part of the orders. Every other order, when they defer to Johns Hopkins, it again ties it back into, and by the way, you have to follow your own rules and rights that you've given. And then we go through to the December 27th order on page 7, and we go through the specifics of that. Again, I tried to track in readable, because some of the orders, I think everyone will agree, are difficult to navigate for us, and because there are inherent inconsistencies. And for the jury to do that by just putting the data out there, which may be, from appellate purposes, the
the cleanest, still, I think it is overall better, and the appellate court would understand the problems with just reciting the terms of the orders because of the inconsistencies involved and the fact that the jury's going to come back and say, well, this order says this on this time, but then on this time the order says this, and what about inside the order itself? The order says you can do it this way, but then down here it says you can't do it this way. And there are plenty of those in the orders as drafted in the shelter action. So then on the last page, you'll see, again, the caveat, which I put at the end after the dependency order, January 13th, discharges Maya. And that is, so it speaks for itself that none of the above orders provide them with immunity or other protection. It should be from plaintiff's claims for specific events and then false imprisonment, so on. The only other question I have in conclusion is the issue about the ketamine order. The defense has made much in the case, well, I believe will and has to a certain extent, talked about whether or not the Maya not using ketamine after she left was some indication or admission that the plaintiffs...
I see that as a different total issue than talking about this visitation.
Yes.
That's not.
I'll shut up about that.
Let's not mix those concepts.
Got it. Well, then I'm done. That's my explanation for the order. Obviously, open to whatever suggestions and comments.
Your Honor, the truth is Mr. Anderson's just never wanted those orders in front of the jury from the first day of this trial. You've been trying to get them in front of the jury now for 2.5 weeks or longer. I spent more than a day trying to put together something that I thought would be as concise as I could that quoted those orders. I don't know how much time you spent, but from my read of this, you rather carefully took those orders that I had provided to you and put them into simple English and was accurate about what is in them. And, all this was done, my order was submitted to you, I don't know, sometime middle of the latter part of last week. And now when we're ready to read it this morning, he wants to make a wholesale change to the whole thing. Mostly he wants to take out the sections he doesn't like and leave in the sections he does like. And so my front end on this is that I do believe that your provisions of this were an accurate transition from the orders I gave you to something that will hopefully make the jury understand it better and faster than what I had provided to you. So I don't think it needs all of these changes. I did know, by the way, that the last time we talked about these orders, we talked about, because the October 14th order was effective October 13th. I'm pretty sure the last time around we called it the October 13th order. Maybe we should say consistent on that. But the rest of this, I mean, unless you have questions about it, I think that you did a good job, and I'm content with you staying with what you wrote.
I am not going to change horses at this point in time. I believe that the proposed changes that Mr. Anderson would make this not a neutral and balanced recitation of the orders. So I'm going to stick with what I said with
with your changes?
Change this morning, and obviously not including that one sentence that I continue to struggle with. And again, we can continue before this actually gets put into the final package that goes to the jury after all the evidence is in. We can massage the language a little bit more, but I'm not going to. Now, I will say if the parties want me to take out the birthday order and go from 5 orders to 4 orders, I don't think that changes anything, so I'm happy to take it out if you want to leave it in.
For clarification, actually from tribal lawyers as well, has there been any reference that we disobeyed in any fashion?
No, that's my point. I mean, there's no allegation that
I think it may need to be added in later, depending on what they do when Kathy B's on the stand, but for this juncture, I think it could come
It's a
out.
half of a page, so it doesn't materially change anything. So if there's the possibility that it's going to be necessary, I don't want to tell them there's 4 orders, and the next time tell them there's 5. So
Your Honor, could we, again, could consider adding the paragraph at the end, which is kind of balances out. There's a short statement at the beginning that doesn't affect the claims, but having that statement at the end after they've heard all this, we think would be important to put it in the right perspective.
I've already said it. I'm not going to say it again in the instruction.
Well,
So
where was it in that instruction? Was it at the beginning? Judge, your order, I don't have it up here with me.
Judge, can we say the 1014 order was effective 1013? I mean, I know it stated 1014, but it was effective 1013.
I think it was on pro time to the 13th. Much to my chagrin, but.
So what I'll do, which was effective, was that 2:30 a.m.?
It was
Yes,
either 2 or
thereabout.
2:30. I've got it. I've got the order. I'll look.
Well, let's do it right this second.
It's effective 2:30 a.m. October 13th, 2016. First page on placement in shelter.
So it wouldn't really, though, affect anything going on during that day.
I don't think there were visitation issues during that day. I don't honestly remember when Mrs. Kowalski was removed from the premises. But we've already explained it to the jury as the 13th. I just think it's important to keep it consistent.
All right.
This is just so you can see what I've just done.
Yes. Thank you.
Anything else on adding that clause? Mr. Anderson?
No, Judge.
Now, the question is, when am I going to read this?
I prefer to have it read now when they first come in, rather than at the end of the day when they're tired or more tired.
So right when the jury comes in?
Yes, sir.
And I must state that I do not agree with making this, and I've been consistent with orders during the first of the trial throughout, that the plaintiffs object to reading 1 or 2 of the instructions that are going to go at the end of the case in the middle of the case, because it unduly emphasizes some orders, instructions over other orders, and by doing so minimizes the other orders. So we again urge the court to not read this during the middle of the trial, because then it will be read twice and the jury will have heard this order, and I believe we had one order earlier 2 times, rather than, and all the remainder ones once at the end. And it does give the impression that these instructions, jury instructions, I shouldn't say orders, control or are more powerful or somehow should be attended to closer than the instructions on all the remainder. So that's our objection to it.
Anything you want to add, Mr. Altenberg?
Well, in context, when Ms. Beatty testifies about these things, knowing these things which are more or less legal facts to some degree is very important. You had talked about giving this to them in the end in writing. I wasn't 100% clear to me whether you plan to read it again at the end as well as give it to them in writing.
I plan on it being in the actual physical packet. That goes back with
I
them.
mean, unless there are significant changes to it, I don't know that I would be demanding that you read it twice so long it was in the packet. They went back and they understood that what they heard once before was in the packet for them to double check their
So
deliberations.
you're suggesting that we not read?
No.
She wants to read
The
it.
jury has had so many questions about these orders.
Yeah.
Questions on a lot of different.
I mean, I want it read right now.
Yes, it
yeah,
needs to be read
but
again
I'm-
later.
And she wants it read twice, so that's fine.
I agree. The jury has been really on this particular issue, so I'm going to read it. I will read it when the jury comes in. Now, here's the next question. I'm not going to physically give them paper right now. I do have the ability to place it up on the screen as I read it.
That's up to your honor, either way.
I don't think that they will be paying attention to the screen and not
They
you.
are taking notes.
I would suggest
Would be
that simply read it.
Well, I'm going to read it.
Yeah.
No, it would
I'm
be
just
helpful
saying
for them to
not
follow
put it
along.
up at this point.
Adults are visual learners. They learn better when they can hear and see something than if they just hear it. So if you've got the ability to do that, I would like to have you do that.
It's going to take them forever to read through all of it while the court is also.
I'm going to read it at my normal speed, and I will. The only thing that makes it a little difficult because I'll be looking this way and I have to control it over here, but I think I can do it without any sort of delay. So
Judge, I have a small issue before the next witness. Can we take that up now?
quickly, yes.
Yeah. So the next witness after you're done will be Miss Alicia Alcide, who's a nurse who is involved somewhat in the taking of the pictures on January 6th. At her deposition, counsel for plaintiff spent a good bit of time addressing why wasn't she discovered earlier? Did risk management look for her? And I guess moving in limine or tennis said that not be an issue it's not an issue for this jury. It was a discovery issue for us and for the court, but would request that not be an issue that be put in front of this jury.
Okay, so I'm sorry, you want me to preclude what precisely?
Questions regarding why wasn't she identified to the plaintiff a year ago? Did risk management come looking for her? Did they send emails? Did they try to find the nurse who was in the photos? Did they, all of those questions that have nothing to do with the issues in front of this jury?
Well, there is certainly something very curious in this case. Since her hands are in photographs, these were seminal to the plaintiff's case for 5 years. I think some questions about was she aware that her involvement in this case was sought, and if so, why didn't she speak up? I don't want to get into the issues of who, if she says, no, I have no idea, then I guess it's over. But if she says, yes, I did know about it, and just nobody ever asked me, then I think that is an admissible fact for the jury.
It's not, it doesn't go to any issue for this jury to decide, Judge.
Just a bias.
It seems that really what you're trying to do is create a spoliation-esque type of argument, which isn't an issue for the jury. There's been no finding by the court of spoliation, so I don't think we need to do that. I'll try something here.
So you're sustaining the request or the objection?
Yeah, I'm going to prohibit that line of questioning.
Thank
So I will grant the oral tennis motion.
I'm not sure of the timing, but again, the defense made any headway on the reports of 2017 reports of employees.
Can we address that after this next witness?
We said at lunch.
Well, whatever. I just know the jury's waiting and the witnesses.
Did they have it?
It's a yes or no, isn't it?
Did you all want to address that again?
I'm sorry, I didn't focus on what Mr. Anderson said.
They would like to address the 2017 further inquiry as to the performance evaluations. Do you want to do that now, or would you like to do it at the next break?
What's the answer?
Okay.
The answer is we do have a subsequent performance review there that spans the time from 2017 through 2018. It's the next performance review, whether that date backs all the way to October. I can't necessarily tell. It doesn't appear to be that way, but they're welcome to it. I'm happy to produce it.
Send it over.
Okay.
That's skirting the issue. We don't have a performance review from the hospital for the time span of this corrective action that's been beating from the end of October through July 2017. It's not there.
Do you want to take a deposition on the issue? Because I'm going to need facts if you're asking me to do anything. I can't just accept representations from lawyers because that's case law says that that's not evidence and it's not the statement of more evidence.
The answer is yes.
And I think they should be required to produce.
I said that they had to have somebody on warm standby. So why don't you get the documents over, and are you able to do it in the next few minutes?
Yep.
Send that over, and then perhaps during one of the depositions that is being played, you can look at it, and then we can talk about when the deposition that you want to take will occur.
Our biggest concern is what the court pointed out, which is were there reviews of other employees at the same time, and so I don't know if they're going to redact or how they plan to do it, but we would like to see some proof of that.
The person from All Children's is going to have to be able to testify as to what happened with everyone else at the time and the salary issues and
Why there isn't one? I understand.
Okay.
Thank you.
So I'm going to take this down until I'm ready to leave. Anything else before we bring in the jury?
Not to the defense.
We'd like to know two things: witnesses for tomorrow, and I think we were told we would get an answer on Father Ray.
Witnesses for tomorrow are Dr. Jennifer McCain.
Who was it?
Dr. Jennifer McCain. I think he's a pharmacist. James Schott. Jason Banker is our billing person. And we're hoping to play the video depositions of Dr. Hanna and Dr. O'Leary at a minimum.
Concerned about the pharmacist Schott. You're talking about the pharmacist from CBS, Schott?
Quorum.
Quorum, same thing.
We can talk about that after the jury leaves for the day. Anything else? Let's bring in the jury. Yes, sir. Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that correct? Correct. You weren't approached by anybody, is that correct? Correct. And you didn't see any media accounts, is that correct? Before we call our next witness, I'm going to give you a lengthy instruction concerning the dependency orders. I'm going to tell you that you're going to get this in writing at the end of the case before you begin to deliberate, but I'm going to go ahead and read it to you now. It should also be put up on the screen as well. I did it properly. Okay. Members of the jury, I told you that I would address the issue of contact allowed by the dependency court during Maya Kowalski's stay at Johns Hopkins All Children's Hospital. This instruction explains the specific dates and restrictions the dependency court imposed in the 5 orders that address contact with Maya Kowalski. The restrictions changed over time, so understanding the dates is important. This instruction will be provided to you again in the court's final instructions to you. The court previously concluded that Johns Hopkins All Children's Hospital had reasonable cause to initiate a call to the Florida's Child Abuse Hotline. Therefore, Johns Hopkins All Children's Hospital is immune from any civil claim which might otherwise result by reason of reporting the suspected abuse. Having said that, Johns Hopkins All Children's Hospital does not have immunity for any of the claims being presented to you as the jury. Prior to October 14th, 2016, there was no dependency court order governing Maya Kowalski's stay at Johns Hopkins All Children's Hospital. From October 14th, 2016 through January 13th, 2017, Maya Kowalski could not be discharged from Johns Hopkins All Children's Hospital without the dependency court's approval. The fact that Maya Kowalski was kept in the hospital under dependency court order, the length of her stay in the hospital, and the fact that Beata Kowalski could not visit Maya Kowalski are not matters for which Johns Hopkins Children's Hospital is responsible under any of the claims being presented to you. The dependency court placed Maya Kowalski in the shelter care of the Department of Children and Families. This status limited some of the parental rights of Jack and Beata Kowalski. It did not limit their right to be informed about Maya Kowalski's treatment and to participate in decisions concerning her treatment. The court will now instruct you on the relevant terms of the 5 dependency court orders. 1. The October 14th, 2016 order. The dependency court entered its first order affecting contact with Maya Kowalski on Friday, October 14th, 2016, which was effective at 2:30 a.m. on October 13th, 2013. Beata Kowalski. The October 14th order totally prohibited Beata Kowalski from having any contact with Maya Kowalski, either in person or by other means such as telephone, email, text message, or by any other form of electronic communication. Jack Kowalski and Kyle Kowalski. The October 14th order required that any visit between Maya Kowalski and Mr. Kowalski be supervised by an adult approved by the Department of Children and Families. Kyle Kowalski was permitted to visit Maya Kowalski with Mr. Kowalski. There was no time limit placed on these supervised visits. The department, not Johns Hopkins All Children's Hospital, was required to make all efforts to identify and select a supervisor to assist with the supervision of these visits. The Department of Children and Families is required to provide such supervision in the cases it files. This order did not create any special rules that the department was required to apply in setting the rules of supervision. The first order did not prevent Johns Hopkins All Children's Hospital from applying its own rules regarding visitation and communication with other patients unless those rules conflicted with stricter requirements in the court order. That is to say, the hospital could not use its own rules to override the stricter rules in the court order. 2. The November 10th, 2016 order. The dependency court entered its second order affecting contact with Maya Kowalski on Thursday, November 10th, 2016. The second order changed the terms of the October 14th, 2016 order regarding contact on a going forward basis. Beata Kowalski. The November 10th order allowed Beata Kowalski to have supervised telephone calls with Maya Kowalski. The dependency court directed that either the guardian ad litem or the case manager supervise these telephone calls. The calls were to be at a time convenient to Johns Hopkins All Children's Hospital, as well as the guardian ad litem or case manager at the Department of Children and Families. The dependency court did not provide that Johns Hopkins could supervise the calls. The November 10th order also allowed Beata Kowalski to have contact with Maya Kowalski through written correspondence. Each of Maya Kowalski and Beata Kowalski could send the other letters, magazines, or other written materials. The dependency court required a designee of the Safe Children's Coalition to review the material before delivery. The designee was required to promptly forward approved materials to either Beata Kowalski or Maya Kowalski. Any material the Safe Children's Coalition designee determined to be inappropriate could be withheld, but the Safe Children's Coalition was required to advise the lawyers in the dependency action of the reasons the written material had been determined to be inappropriate. Johns Hopkins All Children's Hospital had no role in this process. Jack Kowalski and Kyle Kowalski. The dependency court's November 10th order allowed unsupervised telephone and in-person contact between Maya Kowalski and her father and brother. Mr. Kowalski and Kyle Kowalski did have to abide by Johns Hopkins All Children's Hospital's rules, policies, and visiting hours. Maya's treatment was to be given priority, but Johns Hopkins All Children's Hospital was encouraged to provide Maya Kowalski as much contact with her father and brother as possible, provided it did not interfere with Maya's care. Mr. Kowalski and Kyle Kowalski were prohibited from discussing Maya's pain, its causes, the allegations against her parents, or when or how the dependency action would be resolved. Mr. Kowalski and Kyle Kowalski were required to be positive about Maya's rehabilitation efforts and progress, and to follow the recommendation of the Johns Hopkins All Children's Hospital staff as to how to interact with Maya. The number of visitors and the time of the visits required approval in advance, so no unannounced visits were permitted. Friends and other family members. The November 10th order allowed Maya Kowalski and Jack Kowalski to designate two of Maya's friends and two other relatives as proposed visitors, subject to a background check and clearance by the Department of Children and Families. Once cleared by the department, those individuals were allowed to have unsupervised visits with Maya Kowalski. These visits, though, were subject to the same conditions applicable to Mr. Kowalski and Kyle Kowalski as discussed above in the November 10th order. Michael Kelly, Maya Kowalski's attorney. The November 10th order directed Johns Hopkins All Children's Hospital to make the necessary arrangements for Michael Kelly, Maya's attorney, to have in-person and secure telephonic Let me start again. I apologize. I misread. The November 10th order directed Johns Hopkins All Children's Hospital to make the necessary arrangements for Michael Kelly, Maya's attorney, to have in-person and secure telephonic confidential communication with Maya Kowalski. Other relevant requirements. The November 10th order allowed Maya Kowalski to have religious artifacts that did not interfere with her rehabilitation. The dependency court encouraged Johns Hopkins All Children's Hospital to allow a Catholic priest to have regular contact with Maya. if a person authorized to have contact with Maya Kowalski violated Johns Hopkins All Children's Hospital policy, the dependency court's order, or negatively affected Maya's rehabilitation, Johns Hopkins All Children's Hospital was authorized to suspend that person's contact with Maya Kowalski. 3. The December 9th, 2016 order. The dependency court entered its third order affecting contact with Maya Kowalski on Friday, December 9th, 2016. This third order was a special order to address Maya Kowalski's birthday. It allowed Mr. Kowalski and Maya Kowalski's uncle, Scott Kowalski, to visit Maya on her birthday in accordance with Johns Hopkins All Children's Hospital policies. The visit would only be permitted if, in the judgment of hospital staff, the visit would not adversely affect Maya's emotional condition or impede the hospital's rehabilitation efforts. 4. The December 16, 2016 order. The dependency court entered its fourth order affecting contact with Maya Kowalski on Friday, December 16, 2016. That fourth order changed some, but not all of the terms of the November 10th order. Beata Kowalski. The December 16th order permitted Beata Kowalski to have video contact with Maya via Skype, FaceTime, or similar electronic means at times and under conditions approved by Johns Hopkins All Children's Hospital. The dependency court allowed Johns Hopkins to supervise these video calls, and its medical staff could suspend those calls. This was a change from the November 10th order. Despite that change to video calls, the December 16th order did not change the November 10th order's requirements for a designee of the Safe Children's Coalition to review the written materials between Maya Kowalski and Beata Kowalski. Jack Kowalski and Kyle Kowalski. The December 16th order did not change the November 10th order concerning Jack Kowalski and Kyle Kowalski's contact and communication with Maya Kowalski. The provisions of the November 10th order continued to apply to Jack Kowalski and Kyle Kowalski. Mark Zimmerman, Maya Kowalski's attorney. The December 16th order directed that with reasonable notice to Johns Hopkins All Children's Hospital, Maya Kowalski was allowed to have secure and confidential communication with her attorney, Mark Zimmerman. This provision altered the identity of Maya Kowalski's attorney from the November 10th order and slightly altered the obligation on Johns Hopkins All Children's Hospital. Other relevant requirements. The December 16th order did not change the November 10th order concerning other relevant requirements. The other relevant requirement provisions of the November 10th order continued to apply. 5. The December 27th, 2016 order. The dependency court entered its fifth order affecting contact with Maya Kowalski on Tuesday, December 27th, 2016. That fifth order substantially changed contact with Maya on a going forward basis. Beata Kowalski. The dependency court's December 27th order allowed daily video calls with Maya Kowalski at approximately 11 a.m. and 5 p.m. daily. The dependency court permitted, but did not require, the guardian ad litem, the case manager from the department, or any member of Johns Hopkins All Children's Hospital staff to supervise the video calls. Beata Kowalski was not permitted to make any disparaging comments. Johns Hopkins All Children's Hospital was allowed to suspend the video call if Beata Kowalski violated the hospital's policy, the December 27th order, or acted to negatively affect Maya's rehabilitation. Jack Kowalski, Kyle Kowalski, Scott Kowalski, and Wendy Kowalski. The dependency court's December 27th order allowed each of Jack Kowalski, Kyle Kowalski, Scott Kowalski, Maya's uncle, and Wendy Kowalski, Maya's aunt, to have unsupervised, unlimited visitation with Maya. Jack Kowalski was required to announce the visit at least 2 hours in advance. These visitors were required to abide by Johns Hopkins All Children's Hospital visitation policy. They were not allowed to make any disparaging comments. Johns Hopkins All Children's Hospital was allowed to suspend any visit if that person violated the hospital's policy, the December 27th order, or acts to negatively affect Maya's rehabilitation. Other persons. The dependency court's December 27th order prevented any other persons besides the 5 Kowalski family members identified in the December 27th order from communicating with Maya. The order discharging Maya Kowalski from the hospital. The dependency court entered an order on January 13th, 2017, discharging Maya to her father's custody. At that time, the visitation orders ceased. That concludes the reading of the court's instruction to the juries. With that, we're now going to call our next witness.
The defense would call Alicia Alstead.
Face the clerk and raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. All right, put this way.
May it please the court? Good afternoon.
Hi.
There's a microphone that's been pushed out of the way a little bit. If you want to, yeah. Okay. Make sure that you go ahead and say your name for the record, please.
Alicia Alstead.
Okay. Ms. Alstead, are you an employee of Johns Hopkins All Children's Hospital?
Yes.
Okay. And what is your position there?
Registered nurse.
And where do you currently work?
Right now, I'm a nurse coordinator for the Muscular Dystrophy Clinic.
Okay. Can you speak up just a little bit?
I'm a nurse coordinator for the Muscular Dystrophy Clinic.
Okay. Prior to that, did you work on the 7th floor?
Yes, I did.
Okay. All right. And at one point in time, at least January 6th of 2017, were you the bedside nurse for Maya Kowalski?
Yes.
All right. Let's back up a little bit and talk about your education and training. First of all, where did you go to school for nursing?
Florida A&M University.
And just tell us about your education when you graduated.
So I got my AA at College of Central Florida, transferred to Florida A&M University, where I got my BSN, and I also have my master's in public health from USF.
Okay, and when would you have gotten your BSN is a Bachelor's of Science in Nursing?
Yes.
Okay, and that makes you an RN at that point?
Yes.
And when did you get that?
I graduated in 2005. Yeah, 2005.
Okay, and take us through your employment up to joining All Children's.
I started working at All Children's in 2010.
Okay, prior to 2010, where did you work?
I worked at a hospital in Ocala, Florida. It was called Monroe Regional Center at the time, but it's a different name now.
Okay, and you worked in that hospital?
Yes.
As an RN?
Yes.
Okay, all right. You are a pediatric nurse?
Correct.
Tell the jury why you felt called to be a pediatric nurse.
Well, so my brother was born with a hypoxic brain injury, which led him to have cerebral palsy, which is CP. And growing up, he just was sick a lot. He was in the hospital a lot, multiple doctor's visits. But throughout his life, the nurses were always really kind to him and my family, and they always took really good care of him. His home health nurses did as well, and I just knew I wanted to do what they were doing. I wanted to take care of children. I wanted to take care of kids. I wanted to help them like the way they helped my brother. So that's the reason why I wanted to be a pediatric nurse.
So thank you for sharing that.
And he's passed away, so that was many, many years ago.
So you started All Children's in 2010?
Yes.
And were you on the seventh floor?
Yes.
Okay. And remind the jury, they've heard of it, remind the jury what type of floor is the seventh floor, what type of patients?
It's a surgical neurosciences unit.
And for how long were you on the seventh floor?
12 years.
Okay. So it's fairly recently that you changed your position?
Yes.
Okay. And what was the reason for the change?
I just had a change in life, and I needed to be more available to my daughter, to take her to school and pick her up. That's not feasible with a 12-hour shift, so I had to find another job to be able to do that.
So back in 2016, 2017, what shift were you working?
It's the day shift.
And is that 12 hours, 7 a.m. to 7 p.m.?
Yes.
Okay. Let me just ask you a couple of questions with respect to 7th. Is it 7 North or is it just 7?
It's 7 North.
7 North, that's what I thought. Okay, with respect to 7 North, are there some rooms that have video cameras in them?
There is.
Are those just the EEG special rooms?
Yes.
With respect to regular patient rooms, do they have video cameras in them?
No.
Do you recall a social worker by the name of Kathy Beatty?
Yes.
Did you have much familiarity with Miss Beatty?
Only with the patient I took care of.
Okay. All right. And I think we mentioned this, but on January 6, 2017, were you in fact assigned to be the bedside nurse for Maya Kowalski?
Yes.
Okay. Describe for the jury the duties or what your duties were as a bedside nurse.
As a bedside nurse, my job and my duty is to take care of my patient. That could involve in following the doctor's orders, the plan of care for the patient, administer medications, assist with ADLs, which is activities of daily living, helping with procedures, and be an advocate for the patient and family, just whatever the patient needs.
With respect to your duties as a bedside nurse, would you sometimes have to assist patients either with dressing or bathing or other issues like that?
Yes.
tell the jury what was your goal with respect to protecting the modesty or dignity of your patients when you would have to assist with those types of activities.
Do you mean like I'm sorry, do you mean my patients in general? Like,
well, in general, and then we'll get to my.
Okay. To protect their modest, I'm sorry, could you repeat the question?
Sure. So if you had to help a child either undress or bathe or assist them in those types of intimate type of things, what would you do, or how would you try to protect their modesty and their dignity?
Okay. I would make sure that they are covered. If I couldn't get them into like the bathroom, or if there was someone else in the room, I would ask them to leave. But I would make sure they're covered, and I would just protect their privacy.
Do you recall on January 6, 2017, that Maya Kowalski was going to be being discharged from the hospital to go to court?
Yes.
Can we bring up Joint Exhibit 1001-1572? No, 1572. Thank you. Oh, was it there? There it is. Freeze it. Okay. So, do you see your name on there, Miss Alcide? Let's see. Just above the continuous infusions, that line above there, it says result comment. Maybe you could highlight that for us. The second
I see my name, but not where continuous infusion.
No. I was just directing.
Yes, I do see my name under medication administration.
Okay. I'm looking a little bit further down. It says 1/6/2017, 10:56. There we go. Thank you.
Okay.
Under the result comment, it says Alicia D. Alcide. Is that you?
Yes.
And then it says patient discharged with uncle per court order will be readmitted today. Do you see that?
Yes.
Okay. Do you recall, in fact, that Maya was going to court with her uncle that day?
Yes.
Okay. And so this is at 10:58. Does that mean that's the time that she actually left, or on or about that time? That's why you charted it?
I can't say that's when she left. From me, this looks like a medication record, and just going by my documentation, I'm charting that I did not give her the flu vaccine.
Okay.
Because she was going to court.
Okay. But in any event, at some time that morning, the patient had left with her uncle to go to court.
Correct.
Okay. All right. Thank you. Prior to her leaving, were you requested by Miss Beatty to assist with some photographs?
Yes.
Tell us what you recall about that.
Objection, off narrative.
Sustained.
Tell us what you recall about what Miss Beatty requested of you.
She asked me to assist to take some photos of Maya.
Okay. All right. Where did these photographs take place?
In her room.
In Maya's room?
Yes.
So Maya was not moved to another room in order to take the photos?
Objection, leading.
Sustained.
Was Maya moved to another room to take the photos, or were they taken in her room?
I don't recall her being moved to another room to take pictures.
Okay. So your best memory is they were taken in her room?
Objection,
Correct.
leading.
Correct.
What did you have any concerns or thoughts of concerns when Ms. Beatty asked you to come in and assist with taking photos?
No.
And why not?
I just didn't think it didn't seem like a concern to me at the time.
Were you aware that Maya was there under a shelter order?
Yes.
Have you had experience with other kids being placed in the hospital under any type of dependency or shelter orders?
Could you repeat that? I'm sorry.
Sure. In your experience as a nurse on 7 North, have you seen or been aware of other children that have been on that floor as a result of either shelter or dependency orders?
Yes.
Are you aware of other children where photographs have been taken?
Objection, relevance. Sustained.
With respect to Maya Kowalski's photographs, did your prior experience with, let me start that. Did you have prior experience with other children being photographed?
Objection. Sustained.
Okay. All right, so let's go to what actually occurred. Do you have detailed memories of what happened?
No.
Okay, but let's talk about what you do recall, all right? First of all, let me bring up Trial Exhibit 2604006. Okay, so this is, I think, stipulated, a picture taken on January 6, 2017, before Maya Kowalski went to court. Are you in that picture?
Those are my hands.
Those are your hands. Okay, all right. And I see that Maya is in pink shorts, and I think what's been referred to as either a training bra.
Leading.
I want to just, okay.
That one's okay.
Thank you. Do you see that Maya is in pink shorts and what would be referred to as a training bra or athletic bra?
Yes.
Okay, all right. With respect to your involvement when you entered the room, who would be the person that would assist Maya in getting undressed?
The bedside nurse, which would be me.
And with respect to the photographs that were taken that day, that morning, do you have any recollection of either you or Miss Beatty holding Maya down?
No.
Do you have any recollection of Maya screaming or yelling no?
No.
If Maya had been screaming or yelling no, would you recall that?
Yes, I would recall that.
If you had held her down, would you remember that?
Yes, I would remember that.
If Miss Beatty had held her down, would you remember that?
Yes.
All right. So, with respect to photographs that were taken that day, you would have left at 7 p.m.?
Yes.
Objection.
Well, yeah, my shift was from 7 to 7 p.
So if there were photographs taken after Maya returned that day, you would know about that, correct?
Objection. Leading.
Could you repeat the question?
Sustained on the leading.
Okay. Do you recall whether or not Maya had returned prior to you leaving for the day?
I don't remember.
Okay. All right. That's fine. All right. Can we put up Trial Exhibit 2604004? Is that your hand?
No.
With respect to, can we put up side by side 2604006 and 2604004? Okay. So, do you notice the difference in clothings in the photograph?
Yes.
Okay. So, can you describe the difference that you're observing?
In one picture, she has on a shirt or jacket with colorful top underneath, and the other picture, she has on pink shorts and a white sports bra.
Okay. So, and then that's not your hand in the 20041, one, the one on the left.
No, that's not my hand.
Okay. There's been an assertion in this case, Ms. Alcide, that after the photos were taken with the pink shorts and the white bra, that you then stripped Maya, exposed her to Kathy Beatty, and put her in a different bra. Did that occur?
No.
And how do you know that?
I would not. What do you what do you mean by expose?
That you stripped Maya naked, half naked, and Kathy Beatty was standing there watching you do it.
I would protect my patient and cover her up.
That's not something you would do.
No.
Do you recall, in fact, helping Maya change into an outfit to go to court?
Yes.
Do you recall what that outfit was?
I don't recall exactly what it looked like, but it was a dress or skirt, something of that type.
Okay. All right. So let's put up 2604018 and 2604008 next to each other, please. Do you see those photographs, Ms. Alcide?
Yes.
Okay, so in those photographs, again, she's wearing different shorts, different bra, correct? Compared.
Objection, leading. I'm going to overrule that one.
Correct?
Yes.
Okay, all right. Now, I do notice that there is in the 2604018, there appears to be a stuffed monkey of something. Do you see that?
Yes.
Would that indicate to you that this was Maya's room?
Yes.
Okay.
Objection,
All right.
predicate. Overrule.
All right. Let's bring up 2604011 and 2604016. Okay. So, do you see the difference, any difference in that photograph with respect to the blue blanket?
Yes.
And what do you see is different?
In one photo, well, the photo on the right, it's like it's neat. The photo on the left, it's not folded, or it's kind of disheveled a little bit.
So after the initial photographs were taken with the white bra and the pink shorts, were there a second set of photos taken that morning, Miss Alcide?
No, not to my knowledge.
Okay. Did you strip Maya, put her back in shorts and a shirt, fold a blanket, and have her lie down again to take more photos?
Not that I can remember, no.
You can take those down. To your recollection, was January 6, 2017 the first time you had been assigned as Maya's bedside nurse?
Yes.
Okay. Any particular reason, or that's just how it occurred?
I honestly don't remember.
Okay, but you do know that that was your first time of being her nurse?
Yes.
Okay. Thank you.
You're welcome.
Mr. Anderson.
Ms. Alcide, am I pronouncing correctly?
Yes.
The name. Oh, well. So, right before this testimony, did you meet with the defense lawyers about your testimony?
I did meet with them, yes.
How long?
An hour, 30 minutes.
And before that, how many times?
None.
That was the first time?
Yes.
Any phone conversations?
We did have one phone conversation.
How long?
30 minutes.
Okay. Now, you, up to this point of Maya, you had never heard of a child having their clothes taken off for photos, had you?
Can you please repeat
Sure.
that?
Sure. Prior to this event with Maya Kowalski, you'd never heard of a child having their clothes taken off of them for photographs. True?
I've never said that.
Well,
No.
all right. So you have heard of children having their clothes taken off?
What do you mean by heard?
I mean, like Maya's taking all of her clothes except for short shorts and a bra off, like that. You do remember that happening before or not?
Yes.
Okay. With taking do you remember your deposition of August 24th, 2023?
Yes, I remember some of it, yes.
And you were sworn to tell the truth at that point?
Yes.
And that was what? How many months ago? Several months ago, I guess. Is it true at that point you could never remember?
Excuse me, you have a page.
Yes, page 28, line 19. This was the only time in your career you had participated in something like this, that is, taking a child's clothes off.
Could you please reword what you're trying to question right now? Because could you please reword?
Would you agree this was the only time in your career that you had participated in something like this? I mean, taking clothes off a child in order to photograph them.
Like me, myself, taking clothes off of a child?
Yes.
No.
Okay. Well, let me ask you if you gave this answer to this question. Beginning page 28, line 19, strike it. Isn't it true that this was the only time in your career that you had participated in something like this? And when I say, when I say something like this, I mean taking the clothes off of a child in order to take photographs of them. Answer, I can't really recall any other times. Do you recall giving that answer to that question?
Yes.
Would you like to see it to confirm, or?
No, that's...
And nobody from risk management called you about this, correct?
Called me about what?
Taking the photographs?
When I was initially contacted about this, yes, they did they wanted me to confirm that those were my hands in the photograph.
Okay, but I mean at the time that it was done, had you been in contact with risk management?
No.
So your
You mean in 2017?
Yes, ma'am.
No.
So your directives on what you were supposed to do came from Miss Beatty, is that right?
Correct.
All right. And during the course of this, you changed Maya's clothes, true?
Yes.
And in fact, up until this point, well, strike that. It actually came to you or whoever else was in there taking Maya's clothes off to the point where large parts of her skin was exposed. Everything but her training bra and her short shorts. True?
Could you please repeat what you just said? There's
Sure,
a lot of words. I'm trying to just...
Well, absolutely. You had never, up until this point, you couldn't recall how it happened that Maya's clothes came off to the point where large parts of her skin were exposed, everything but her training bra and short shorts.
Yes.
So that did happen.
What happened?
Maya's clothes were taken off down to the point where she was only wearing short shorts and a training bra, right?
Yes.
And you only remember one set of photographs being taken.
Yes.
Now, who else was in this room besides you and Miss Beatty?
I only recall me and her being in the room.
All right. Well, let's take a look at some photographs, because I could have sworn I heard you state on direct examination that those are not your hands. Do you have photograph?
What's the number? Spells the number.
Well, it's 2604-006, but I'm looking for the one where the hand's pulling down. The council had it. Do you remember the number? You just had it up.
I know, I'm looking.
Thanks.
Zero, 004.
004. Let me bring that up. Can you see? Let me know when you can see that.
Do you need that, Harden? 2604 004.
Okay, I see it.
Okay, no, I think, is that your hand there?
No.
So who else was in the room, ma'am?
I only recall me and Kathy being in the room with Maya. I don't know whose hand that is.
Okay, but it's not yours, right?
No.
Because if we look at 2604-006, there's a wedding ring on the hand of that person.
Those are my hands.
Those are your hands?
Yes.
The other hand we just saw going back to 004 did not have a wedding ring, I don't believe. Right hand there? True?
Correct.
Okay. So, in the photograph, so it would appear then that you and Miss Beatty were not the only people in that room. True?
I did not say that. I'm saying that I only recall me and Kathy being in the room at the time.
Okay. There was only one set of photographs taken, right?
I did not say that. I know of a set of photographs that was taken.
Okay, but there was only one set of photographs taken, to the best of your knowledge.
Yes, that's...
This session.
Yes, this session of photographs.
And in this session, Maya Kowalski was changed how many times?
I don't recall all of the details of the photos being taken, but I don't recall there being two different sets of photos taken with me being present.
I understand it. So there's only one set of photos that we're aware of, correct?
Correct.
Okay. Now, in those photographs, in this session here, how many different sets of clothing did you put on and take off Maya?
I don't remember the details of the clothing, the taking them off and putting them on, but as a bedside nurse, I would have helped her.
Mm-hmm. So there was a different set of shorts on at some point, right? You recall those photographs?
I would have to see a picture. I'm going to see these two pictures.
Okay. All right. And then we've got the pink shorts here, right? And then you testified you assisted with dressing her with a dress, was it, for court?
A dress or a skirt to go to court, yes.
No skinny jeans, right?
No, I'm sorry, what was that?
Sorry. So that would be taking her out of the pink shorts and white training bra to put on the blue shorts and I guess that's another training bra or vice versa, right? That's one change.
Are you asking me a question?
Yes, ma'am. Is that one? I'm asking if you could agree with me that that is one change that happened while the photographs were being taken to get her from the blue with the floral pattern bra to the white training bra with the pink shorts.
I don't recall, as I stated earlier, I don't recall the details of the pictures being taken and the different clothes, but I don't recall putting two different sets of clothes on her. I only recall helping her put a dress on or a skirt to go to court.
Okay. Now, how, strike it, you don't recall actually putting up a blanket or a towel or anything to shield Maya in either of these changes, do you?
I don't recall any of the details of these pictures being taken, but I know that I take pride in my job as a nurse,
yes,
in my profession, and if my patient was exposed, I would try my best to protect her privacy.
I understand that. I'm just saying in this instance you can't remember whether that happened or not.
I cannot recall it.
Now, Miss Beatty, she wasn't the social worker that was a regular on your floor. What was it? Something North? 7 North?
Yes.
Okay. The social workers, are they usually assigned, or did you have a social worker assigned to your floor?
We did. There were different social workers.
Okay.
I don't know.
But generally speaking, a social worker would be assigned to a floor for a period of time?
Yes.
Okay. And when Maya was having her pictures taken, she was in distress, wasn't she?
I don't recall that.
She was crying, wasn't she?
I don't recall her crying.
She was protesting, don't do this, don't take my clothes off, wasn't she?
I don't remember that.
We bring up 006 again. 006. Do you see the bit of her mouth there?
Yes.
That doesn't look like she's smiling, does it?
It's hard to tell if I can't see her face.
Okay. And in fact, you were holding her hands there, to comfort her and support her. True?
It appears that she is holding my hand and I'm holding her hands back. And yes, as a nurse, I'm there to support my patient
And comfort her.
and comfort.
Now, why would a 10-year-old girl need comforting and support if all that was going on there was just taking her photographs?
I don't understand what you're asking me right now.
Were you there when Maya was readmitted after court?
No.
That would have been on at 8:18, I think on a 24-hour clock on January 6th.
I don't remember that. I don't remember her coming back, no.
Okay. Can we bring up 1002-0249, I hope? Does this indicate that you were there on that day, the 6th, up to what, 6 o'clock at night?
Well, it looks like I charted not done task duplication.
Okay. Maya came back before 6 o'clock at night, did she not?
I can't say yes to that. I can't agree to that just by this record.
Sure.
Because it says not done task duplication.
Thank you, ma'am.
You're welcome.
Ms. Corrales?
Yeah. Can we put up, please, Trial Exhibit 2604007 and 2604018? Next to each other, please. Does this appear to you to be pretty much exactly the same pose in both photographs?
Objection, leading. Not leading.
Overruled that one.
Thank you.
Could you repeat the question?
Sure. Is the photograph of 007, what is that a photograph of? Regarding Maya, what is that a photograph of?
It's a picture of her back.
Right. And what's the photograph of 018?
Picture of her back.
Okay. So, with respect to your recollection that morning, you've testified several times that you only recall one set of photographs being taken, correct?
Correct.
So photographs were taken after Maya came back, and after you were gone, you wouldn't know anything about that, correct?
Objection, leading. Overruled on Keith.
Do you want me to repeat the question?
Sorry.
Would you know about any photographs that were taken after you ended your shift and were gone from the hospital?
No.
Even if they were taken the same day?
Correct.
Okay. So, with respect to these, they're calling it a set, but these multiple photographs with two different outfits taken that day that were produced, do you know whether or not all of those photographs were taken at the same time or two different times?
Leading.
Overruled.
I can't recall. I don't know.
You don't know, right?
I don't know.
If they were taken two different times. However, okay, but you do you recall that with respect to assisting Maya with respect to getting ready to leave, that you helped her into some type of court attire?
Correct, yes.
All right. Let's talk about changing Maya. If Miss Beatty was in the room when you wanted to assist Maya with changing, what would you ask Miss Beatty to do?
I would ask her to leave, or I would take Maya into the bathroom. cover her up to make sure that she had privacy.
Okay, and why would you do that?
Because that's what I do as a nurse. I protect my patient.
Thank you.
You're welcome.
Anything further, Mr. Anderson?
You covered her to protect her from its beating, correct?
Objection.
I don't recall the exact.
Sustained.
None further.
Members of the jury, do any of you have any questions? Why don't we try to do this at the sidebar? Hey, members of the jury, in amongst the questions, there was a question about the dependency order instruction I gave you. What I'll tell you is I will give you the dependency order and what I'm able to say in the final package. I understand there was a question, but it will be what it is in the final package. Now, nurse, is it Alcide?
Yes.
Do you know if Maya's parents consented for the photographs to be taken?
I don't recall that.
Did Kathy tell you she had obtained consent?
I don't recall that.
Did the photographs get placed in Maya's medical record, or do you know the purpose of these photographs?
I don't know if they were placed in the medical record or not, and I honestly don't remember why the photos were taken. I just know they needed to be taken before she went to court that day.
Next question. How many bedside nurses were assigned to a room during the 7 a.m. to 7 p.m. shift?
How many nurses were assigned to
a room during the 7 a.m. to 7 p.m. shift?
One nurse per room. One nurse.
And there was a question to the court that I can't answer. Next question. Is this timeline and clothing correct? Helped Maya get down to shorts and white bra. Is that the first step?
I don't recall the exact clothing and from my memory of the clothing that she wore for the photos. But in the picture, she was wearing the white sports bra and the pink shorts.
Then the photos were taken, and then you helped Maya into the dress?
I don't recall. I'm sorry, I don't recall the exact details of the photos being taken. It was many years ago, but I do recall being there as an assistant witness to help her to take the photos, and I remember helping her into a dress or skirt of some type before she went to court.
Was she in the same bra, or was her bra changed?
That I don't remember.
What color was Maya's court attire that you helped her change into?
I don't remember.
Ms. Croyles, that's the conclusion of the jurors' questions.
Nothing further.
Mr. Anderson.
Trial Exhibit 2604-5.
Was that the shirt that she came in with?
Came in.
Well, when you came in, was she wearing that shirt?
I don't remember what she was wearing. I don't recall what she was wearing.
Does that look like a happy child to you?
No, she does not look happy.
Thank you.
Ms. Croyles.
1 second. Nothing further, Your Honor.
Members of the jury, any further questions? This witness be excused and released from all subpoenas?
Yes.
And thank you for being here.
You're welcome.
Is it the deposition next? Trying to remember.
Judge, this is the third time lucky or 3 strikes you're out, but we're going to play Dr. Malik. You've tried twice to do.
And that's an hour, just under an hour, right?
I think it's shorter even now, but I don't. 15 minutes. We cut off another 5 minutes, Judge.
That sounds like an 8 minutes and some odd seconds.
Yes.
So now that you know that it's 50 minutes, do you want a break or do you want to do the deposition first? Seems like the majority says do it.
Maybe we approach it 1 second then.
Sure.
Because we were moving way too fast.
Okay, the jury's out of our presence. Mr. Anderson, I think the phrase you're looking for is we are proceeding at impulse speed and not warp speed at this time. 5-minute break, and we're going to get the clip report. Thank you. Please be seated. Did we get the report, and are we okay?
While they're doing that, Judge, I had a question. I would dearly love to bug out, but we had that one issue about the pharmacist shot and it's being held for two purposes.
You want to deal with it now while this thing's being printed?
Yes, that would allow me to get out of here. At some point, I'm going to have to sleep. It's optional, but I really understand.
What's the issue?
The issue, you may recall, Judge, that there was an issue about a particular prescription that said, was it terminal on it? Or?
Patient is terminally ill.
Right.
I thought that was out, and we're dealing with it.
That's exactly my point. The other part, I don't think is a problem with it, but the court's already ruled on that, and I didn't want to have that sneak in someplace.
Your Honor, we're okay with, we know that patient is terminally ill is out. We would still like to move the prescription in as a medical record without the patient is terminally ill designation at the bottom.
I know you don't like tag team.
This goes also to the IV ketamine?
No. The prescription is for a number of different opioids, and it would refute Dr. Kirkpatrick's testimony.
Put up the prescription, please, so I can actually see what the line is.
While they're putting it up, the argument would be the actual prescription itself would still be relevant. It was a prescription written by Dr. Kirkpatrick during the proffer for Mr. Hunter. He agreed this was a prescription he validly wrote. The 403 objection is just over the terminal sense. They're not arguing that a prescription written for this patient was invalid. It was sent to the pharmacy to be filled. The reason why the defense needs it, besides just being a medical record, is it goes to our theory that the medications being prescribed prior to this, they jumped right to heavy-duty narcotics to dispute what Dr.
You're telling me it has nothing to do with IV ketamine?
Not a correct.
It has to do with IV Dilaudid.
Well, I'm just...
Yes, it's 3043.
I'm still waiting for it to be put up.
3043. And there was also a PCA pump to administer that Dilaudid. That's one of those pumps that a patient can click and self-administer.
The fact that you'll notice the date of this is November 5th, 2015, after several rounds of ketamine. It also goes to show that the ketamine treatment that Dr. Kirkpatrick is extolling is not working.
And isn't this the medication to get us, or get Maya to Mexico?
Yeah.
Yeah.
So what did I do with, because didn't we keep out all of the, I'm trying to remember what the ruling was with respect to
the comments back and forth about this issue.
So far, you've kept out the comments on terminally ill. We'll redact patient is terminally ill out. We can redact the whole scribble below. We just want the prescription in to show that the medications are being written. That, yeah, it goes to the extent of how sick she was and how much pain medication she needed as she was going to Mexico. So we can redact below the signature line if the 403 objection is patient is terminally ill, but we need the data. Yeah, and Mexico is not for another 3 weeks after this, so it goes to show how poorly Maya was doing that time frame. It all goes to the defense team to contrast to the plaintiff's argument that this was a miracle drug and the freight train heading towards college, and here we see, morphine. So, I mean, the 403 was just for the bottom comment, and we would agree to take up the bottom comment. Perhaps we may not need a witness on this issue. I don't know if there's anything else Shot has been called for.
Shot's there just to talk about this prescription as well as the Dilaudid PCA pump and the accoutrements associated with it.
I honestly don't know the answer to this question, but I don't know that this prescription was ever filled. I mean, in other words, there was this issue over the insurance company, and the pharmacist was writing this on there, this terminally ill comment, in hopes of getting this filled. And I think there was some back and forth about that. Those are the comments Your Honor's excluded, and I don't think it ever manifested.
Here's where I'm at. Here's where I'm at with this. This case isn't about the specific medicine in 2015. There's already been a ton of testimony about the various things that she did have. There was testimony about interval medicines to get her to Mexico, and it almost seems like this, I talked about the terminal ill, so even if we were to redact it, I don't know what this does for this particular case. It's either cumulative or if it's being used for some other purpose that is a backdoor for something, then in that regard it'd be a 403. So I don't see.
I'd be happy to articulate. And for the record, when we say we're agreeing to redact patient is terminally ill, that's based on the prior court's ruling. We're not waiving the fact that we believe that's relevant. The reason why this prescription is relevant is because it goes directly to the heart of the defense case that all of these medications were required for Maya Kowalski to keep her from having this exquisite pain. That the plaintiff has put on a case, and again, the most memorable witness of all was Robert Tremp saying how well Maya was doing. She was a freight train headed to college. The ketamine was working. How dare you interrupt the medication regimen for this patient? And what this shows is Maya's condition before. They are accusing All Children's Hospital of either causing or aggravating her condition because we interrupted the medication regimen. This is the pre, and this is a very, very important record for the defense because it shows extremely significant opioids that the prescribing physicians were given this patient. The plaintiff has put this front and center of their opening argument that all of this, what was going on before All Children's, was mild, not a big deal. She was thriving. Look at her in the pool. She's doing well. And then they want to contrast that with, you had no right to stop at any of these medications. She was going to be doing great until what you did on the wean. And that's why we need to give this jury a very honest picture of here is all of what Maya Kowalski required. I respectfully can't see how just a prescription written by Dr. Patrick in real time for significant opioids to address her pain wouldn't be relevant for the jury to understand the before and after. I don't see how a prescription would be prejudicial.
Well, I know I made a comment about this in written order 4 or 5 months ago, but it seems, and both sides do it, that the number of adverbs and adjectives and the hyperbole as to every single issue makes it more and more difficult to differentiate the true important issues versus what you want and are just trying to use hyperbole. This is a time period before the ketamine coma. a year before the admission of Maya Kowalski. And so it seems to me that we don't need to put every single piece of paper, especially when there's already been testimony that she had lots of drugs and needed more drugs to get her to Mexico.
Dr. Kirkpatrick said the exact opposite in his testimony. Dr. Kirkpatrick's testimony on this was that he exhausted all conservative management before he finally sent her to Mexico, and this contradicts his testimony on that. And I will say to the court that the defense would consider this piece of testimony about these significant opioids and with the terminal that I understand your court's ruling and the IV ketamine being given at home as two of the most 5 significant pieces of evidence in the defense. I apologize if there's been hyperbole about it, but it's a prior medical record of a plaintiff in a medical malpractice case showing the extreme difference before.
Was this filled?
I can double check that for Your Honor, but the fact that Dr. Kirkpatrick signed a prescription where he is authorizing under the law in his FDA license that he believes it is medically necessary for Maya Kowalski to have hydromorphone PCA pump on a 30-minute lockout due to her extreme pain is absolutely relevant to the case again to show the before, because if they're going to accuse all children of aggravating a pre-existing condition, we need to understand the pre-existing condition. I can find out whether it's filled, but there's no question Mr. Hunter proffered Dr. Kirkpatrick, did you write this and did you sign this? And he agreed this is a valid prescription. So it at least goes to the fact of whether Dr. Kirkpatrick thought that these doses of hydromorphone through a PCA pump were medically necessary to control Maya's pain.
And it's so important we don't know if it was filled.
Well, we can ask Dr. Schott whether it was filled. I believe it was.
Then wouldn't the pharmacy records have it?
Yeah, as I'm speaking,
are the pharmacy records in?
Are the pharmacy searching them right now? Mr. Hughes is looking for those right now.
If the pharmacy records are in, then...
Judge, why don't we just ask the witness? I mean, I feel like we're getting cut off at the knees here with this stuff based on some value judgment of perceived importance on the court's part, and it goes to the jury with the weight of the testimony. If it's not filled, then fine, we can deal with that. But we believe it to have been filled, and if it was, it's a significant piece of evidence regarding the pre-existing condition of this patient.
Turn the feeds back on. Okay, let's bring back the jury.
All rise, jurors entering.
Okay, please be seated. Now you probably feel like my wife does when I say 5 minutes. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And no one has approached you in the last 5 minutes. And you haven't seen any media accounts. Is that correct? Ms. Crowells.
We'll call by deposition. Dr. Farhan Malik.
Do we want the lights to be as is? The majority says to keep light.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you have to give the truth, the whole truth,
Yes.
Please state your name for the record.
Farhan Malik.
And you are a physician in practice employed by Johns Hopkins All Children's Hospital?
Yes.
And where'd you go to college?
New York Institute of Technology.
Year you graduated?
2005. 2005. Yeah.
Medical school?
New York College of Osteopathic Medicine.
And where's that located?
It's also located with New York Institute of Technology. They're both in Long Island.
And what year did you graduate your 4 years there?
09.
For the benefit of the jury, can you give them a very brief description of the differences, if any, between an MD and a doctor of osteopathic medicine?
Sure. The degree is actually called a DO.
Yeah.
It essentially is very similar to MD schooling. You just take additional courses in osteopathic manipulation, which I liken it to chiropractic. And so you have the option of practicing that when you graduate versus just practicing as a regular doctor.
Again, I don't know how accurate this is because I'm just reading off the internet, but osteos tend to be literally more hands-on with the patient. I mean, there's more manipulation and testing, feeling, touching, that kind of thing, and diagnosing?
You take classes in the manipulation aspect of it, and if you choose to practice that, once you're done, and incorporate that into your practice, if you're in a field where you can, such as internal medicine or general practice, becomes a little different when you become more and more specialized.
The area that you chose to go into was critical care with a focus on cardiac, is that right?
Yes, cardiac intensive care.
All right. And where did you do your residency?
Newark Beth Israel Hospital, so it's the Children's Hospital of New Jersey.
And what year did you, what years were those?
So that would be 09 to 2012.
And after residency, what did you do?
I did my fellowship in pediatric critical care at the University of Texas in Houston.
Right. And what year were you licensed to practice medicine in the state of Florida?
2015.
So at the time you saw Maya Kowalski and her October 7th admission, you had been a licensed physician in Florida for 15 months? So you made 12, May, June, July, August, September. So about 16, 17 months?
Yes, I believe approximately.
You were a fairly young doctor, relatively speaking, experience-wise.
Yes.
Were you licensed in any other states?
New Jersey.
And what year were you licensed in New Jersey?
That would be at the start of the conclusion of my residency, so that would be 2012.
So after your fellowship at UT Houston, where did you go?
Johns Hopkins Old Children's.
And what was your position?
Pediatric critical care physician.
And what does a pediatric critical care physician do?
All things involving intensive care. So if a child gets admitted to the ICU for any number of reasons, trauma, sepsis, after surgeries.
Would it be fair to state then that as of October of 2016, you were not an expert in complex regional pain syndrome / also known as RSD?
Yes, that's very fair.
Would it be fair to say that as of October of 2016, you were not an expert in medical child abuse?
Yes.
You were not an expert in factitious disorder by proxy?
Yes.
You were not an expert in a conversion disorder?
You're listing a lot of psychiatric disorders that, no, I am not an expert in because I'm not a pediatric psychiatrist. So.
And then Munchausen by proxy, same answer?
Yes.
Not an expert in that either. All right. When was the first time you met Dr. Sally Smith, if you recall?
I don't believe I've actually ever met her.
Have you ever spoken with her on the phone?
I can't recall exactly, but I might have spoken with her regarding this case.
Did you know of her, even if you didn't speak to her or see her?
Yes.
And what did you know of her as of, say, the period before October?
That she was our go-to person to speak to if you had concerns of child abuse.
On any of Maya's prior admissions or visits to the ER at ACH, had you ever run into either her or her family?
No.
So the first time you ever met any of them would have been on that October 7th visit?
Correct.
And do you know Dr. it's Tepes Sanchez, but I think everybody just calls her Dr. Tepes. Is that right?
Correct.
Okay. Did you know Dr. Tepes before this admission?
Yes, we're colleagues.
And how long had you worked together?
A couple of months.
What were you told on the phone and by whom?
I received a phone call from the ER attending, Dr. Posey, about essentially Maya coming in with these complaints, the requests of the family, their inability to perform any radiologic studies like a CAT scan because there were complaints of abdominal pain, and her inability to really do anything substantial to help, and the request for an ICU bed so that we could treat the pain symptoms.
But did you have access to this record by the time you became more involved in Maya's care?
Dr. Tepes' record?
Yes.
Yeah, once it was input into the system, then if I needed to refer to it while I was taking care of Maya, yes, I would have had access to it.
When was the first time you ever actually met Maya or any members of her family?
That Friday night.
In what
once she got admitted. Well, the case was unusual, and it required a lot of prior planning, and so Dr. Tepa and I, especially because we knew that multiple care providers would be seeing her throughout the weekend, got a sense of what was going on from the family and Maya. And so that Friday night, even though she was the one taking the history and putting in the orders, or her team was, Dr. Teppa's team was, I made sure that I familiarized myself with all the ongoings so that I could respond if a problem arose.
But it did make you aware that she was being treated by Dr. Barr, a neurologist in Orlando, right? Followed by Dr. Barr, fourth line down?
It made me aware that she received treatment from multiple providers, which made me concerned enough that we should treat her symptoms as significant, and we shouldn't dismiss it. And actually, I recall distinctly saying that we need to approach this like complex regional pain syndrome, because there's no evidence that this isn't complex regional pain syndrome and that she isn't having a pain exacerbation. If I recall distinctly getting up in front of the ICU and speaking to multiple nurses who were concerned and other care providers like nurse practitioners that were concerned about our approach in delivering this amount of ketamine and this amount of propofol and Precedex without the same type of monitoring that we normally do in patients who get this type of medicine, things like arterial blood lines, which measure blood pressure, continuous oxygen saturation. In reading all this and have gotten a cursory history, hearing about all of it, I knew that we should approach this as if it's real, which it could have well been at the time that we got presented with her.
When was the first time you personally spoke with any of her prior treating physicians?
I didn't speak personally with any of her prior treating physicians.
No one related to you anything about why or her history with that doctor in Clearwater?
No, just the diagnosis of complex regional pain syndrome and the need for ketamine.
And it documents here, Dr. Hanna was contacted by our EC and stated she received 1,250 milligrams of ketamine with 50 milligrams of 2% lidocaine, 750 milligrams of magnesium sulfate, and 4 milligrams of Versed, right? Fairly potent pain relievers, a couple of them there, right?
Absolutely.
Abdominal ultrasound and abdominal CT were ordered, but mom refused these studies, stating she wanted the propofol to have started prior. So mom didn't refuse those. She wanted the child to receive pain med before she had that kind of testing?
Yes.
Were you aware that both a PICC line and a port were surgically placed in Maya at All Children's Hospital?
Yes, I was.
And one of the purposes of the PICC line and then port was for ketamine infusion?
Yeah, I was aware that the PICC line and the port were placed, yes.
And one of the purposes was for these infusions?
Yes.
And so, did you speak with the surgeons and anyone involved with those procedures?
No.
Did you speak with Dr. Kreisman in endocrinology at ACH about his experience with the patient?
No.
Did you speak with Dr. Jackman in endocrinology about her experience with the patient?
No.
What doctors who had followed this patient in prior admissions to ACH did you speak with at this time, October 7th through 9th, let's say?
Once again, it wasn't my patient. I was taking care of her adjunctively with Dr. Teppa Sanchez, so I didn't speak with any of the physicians.
Do you know Dr. Tempo Sanchez did, insofar as any conversations you recall having with her?
The only ones that I was aware of, like was mentioned in this note, was Dr. Hannah.
Can you expand a little bit on the instructions to the ICU, or maybe it's the ER team, I'm not sure, about treating this as CRPS? What in essence did you tell them?
What did I tell the ER?
Well, you said you got up in front of the
ICU,
sorry. In front of the ICU. What did you tell them about, other than this is CRPS and we should treat it as such? Anything else you said to them, you remember?
Well, the concern was that she was in a lot of pain to the point where we couldn't apply a blood pressure cuff, take vitals. Part of being in an ICU is frequent vital monitoring, especially when you're delivering a lot of these heavy dose medications and stop your breathing, can lower your blood pressure, lower your heart rate. Given the uniqueness of the situation, but our inability to know, otherwise that this isn't CRPS or to keep treating it like it, I essentially got up in front of the ICU. I said, we have to treat this like CRPS, and we're going to try to monitor her with the best of our ability. And if we see signs where we feel like the medication is slowing down her breathing, or if it's affecting her blood pressure or messing with her perfusion, then we stop. But otherwise, we treat this like we're being asked to treat it.
Was there any resistance from any of the staff about treating this as CRPS?
There were concerns. I remember nurses being very vocal. I don't recall which nurses or what was said, but I just remember it being a very heightened emotional environment.
What were they vocal about?
The situation where all this amount of dosing for these medications without that invasive monitoring and without that frequent monitoring.
Did you ever speak with Maya this first day?
She was in so much pain that I couldn't speak with her.
Who was in the sit-down from the Kowalskis? Jack, the father?
I think it was both the mom and the dad. Yeah.
And in this meeting, were they open to your suggestions?
Yes.
How would you describe the meeting? Was it professional, cordial? Was it confrontational? What was it?
The very first meeting was professional.
No raised voices, no accusations, nothing like that?
No.
At this point, then, had you examined Maya yourself? Or you?
Well, I couldn't examine her because she was in a lot of pain, so she wasn't answering any questions. She wouldn't let anyone touch her.
But the nurses don't set the course of care or diagnose, do they?
No.
So you were following what Dr. Hannah had prescribed with the exception of the ketamine dosage?
We were following what we thought could help alleviate the severity of her pain symptoms. I don't believe Dr. Hannah was giving her propofol.
Okay. All right.
And so we took her pain symptoms as being so severe that she needed to be basically induced into anesthesia.
Pain team, including Dr. Dolan and Dr. Elliott, were you included in that part of the conversation?
Yes.
What did they say, by the way, about CRPS, her possible sources of her pain? If you recall.
From what I recall, they wanted to treat it like CRPS, and were aware that she was receiving outpatient ketamine infusions, and were aware that she had undergone treatment in Mexico, and therefore we came up with, as a group, the dosages that we came up with.
Anything else you recall from this part, this first evening, and I guess what is contained in Exhibit 2? Anything else?
I mean, just that, once again, we approached this as a team, which included the nurses, the physicians, the pain management team, and my concern was that we approach it to the best of our ability, like a diagnosis of complex regional pain syndrome.
Was the idea here, you started in light of the concerns over monitoring, you'd start out with a lesser dose, see if it worked, didn't work, and then up it if necessary?
Yeah.
And that's prudent medicine, right?
Yeah.
You see what works.
Yeah.
Right.
You go low and you go slow.
You told him, how many days did you tell him you expected her to be in there?
I don't recall.
Was there any limit in your mind?
There was, I believe, a plan that we came up with. And as soon as she would have been off those medicines, then she would have been transferred out of the intensive care unit to a less acute unit.
Off of those medicines? What do you mean off of those medicines?
Off the continuous infusions.
Not off ketamine, just off continuous infusion.
Yeah, continuous infusions can only be administered in an ICU given our resources, our ability to frequently monitor, our nurse to patient ratio. Once she was off those infusions, continuous infusions, she would have been transferred to a less acute floor.
Tell me up to this point, how many times you had seen Maya Kowalski?
So she got admitted Friday night, and then Saturday, I was there, involved once again along with Dr. Tepa Sanchez, and then Sunday, I believe I was on call 24 hours, and so I had seen her approximately 4 to 5 times.
4 to 5 times, and for how long each time?
Each time about maybe 5 minutes, 10 minutes.
All right, so something between 20 and 50 minutes total.
Yes.
And how many discussions had you had with Beata or Jack Kowalski at this point?
At this point, I had, I think, 3.
And where were those discussions?
They were mostly in we have a conference room outside of the patient's room.
On which floor?
Same floor.
On the PICU?
Yeah, inside the PICU.
All right, so tell me about the one on Saturday.
Saturday, I don't think involved us sitting down in the conference room. I believe it just involved us outside of the patient's room.
And what was the topic?
Topic was how is she responding?
How was she responding?
Not very well. There seemed to be no mitigation of the symptoms.
And so what did you discuss?
On Saturday, that we would continue the same treatment plan, but that most likely we would be coming down and completely stopping by Sunday, since we didn't see any change in symptoms.
And why not increase back up to where the physicians that had been following her for a year or so?
Because we, I believe she didn't want to be intubated. She didn't want the breathing tube, nor did we want to put a breathing tube in her. And we weren't comfortable going up on these medicines without securing her airway.
All right, so there's a pain management consult, is that right?
Correct.
Have you ever seen anything in writing about that?
In regards to Maya?
Yes, from pain management?
No.
Well, what did they tell you? And who told you?
Pain management told me that they didn't feel comfortable going up on her medication. and we expressed the same concerns given the lack of an airway. And that was the discussion.
Who said that? Dr. Dolan?
I can't recall if it was Dr. Dolan or Dr. Elliott.
You were not an expert in ketamine infusion for CRPS, were you?
I am not, but I deliver ketamine as an intensivist for postoperative pain and for procedural sedation.
Shagan, I'll just ask this way. You had a different view on the appropriate dosage for ketamine than Maya's attending physicians outside the hospital. Fair enough to say?
Different in the fact that we were not comfortable delivering the same doses that she had been receiving without standard things that we would do, such as putting a breathing tube in, putting a arterial line in, becoming a lot more invasive with the patient. So that's where we, at least personally, I disagreed with Dr. Hanna and the other physicians that you mentioned.
Okay. Those physicians had more experience with this patient, did they not?
I can't speak to their experience with her. I can just speak to what I was presented with and my inability to invasively monitor her, both at the parents' request and at our request, because we did not want to undertake something that could potentially be lethal to treat this pain.
So we had and what did the parents say there?
They didn't want her intubated.
Okay, and did they say the reason why?
I don't recall a specific reason. I just think that, just like anyone, you weigh the risks versus benefits, and the risks of her undergoing anesthesia and getting a breathing tube for who knows how long versus the benefit of alleviating this pain. It didn't make sense to them or us.
Okay, so you then said, all right, well, we can't serve your purposes here. We don't think it's a good idea. It's against our recommendation, but, you know, see ya. Bye.
No, we agreed upon an acute care plan, which were the doses of ketamine, propofol, Precedex, all the while trying to figure out a source of her abdominal pain, trying to get her a CAT scan of her belly, making sure that she was getting nutrition.
Are you saying the parents did or did not want her intubated?
If I recall, they did not want her intubated.
And now Dr. Patel did not want her intubated?
Yeah.
Did you discuss this with Dr. Patel?
Yes.
So, on one hand, the Kowalskis have one attending, and you're an attending physician too, Maya, right?
Yeah.
One attending physician who's saying, I'll consider increasing the dosages here, try to give them more relief, but I'd like to see an intubation, right?
If I recall the context of the discussion, which it was always the case from the onset, was that if we were going to go up on medications, it would probably require her to be intubated. I don't recall what was said, but it was brought up that overall this wouldn't serve the greater good, that the benefit of undergoing the risk of anesthesia and intubation wasn't greater than the risk. And so whether that changed on Saturday with the dad, but then when the mom came, she agreed.
What does that have to do with my question about whether you could blame the parents for a disagreement among the team about intubating or not intubating?
Because it's not blame. We're not saying that the mom or dad were wrong in disagreeing. We're just laying out that we expressed to them that this was risky and that we weren't comfortable putting her at that risk.
you personally are not blaming Beata or Jack for this discussion, or to the extent that there was a disagreement about whether to raise the ketamine or to intubate. Is that fair enough to say?
Yeah.
Just a couple of concerned parents, basically?
Yeah.
Did you at this point talk to Dr. Kirkpatrick or Dr. Hanna about why they had prescribed what they prescribed?
No, I personally didn't.
In fact, in this country, the United States, where there are two methodologies for treating a child, it is the parents who decide which physician they're going to follow, not for anyone else, particularly the doctors. You're aware of that?
We're the ones who were directly taking care of her. So regardless of what prior physicians, future physicians would do, we were directly taking care of her Friday, Saturday, Sunday. So we take a team approach. We like to consider what she's received in the past. We like to always consider the parents' wishes. And most of all, we analyze the risks versus the benefits. If we perceive, using our medical training, using our team analysis, that the risks outweigh the benefits, then I don't care what a physician in the past has done. I don't care what a physician in the future has done. We're the one watching after Maya on that Saturday, on that Sunday. So we came up with a plan. We established a plan with Maya's mother and father Friday night because we knew that there would be issues given her history, given how complex this was, but that no one wanted to risk her dying over perceived pain control. So we established dosages. We said that we would not escalate beyond those dosages. So the meeting Sunday was about the mother's now insistence. And I believe at this time things started to become belligerent. Things started becoming talks of leaving the hospital.
It's in your patient's statement of rights. They can leave the hospital anytime they want.
I would not let any patient safely leave ICU, let alone a hospital, without safely turning down medications and watching for any side effects from those medications, such as respiratory depression, low blood pressure, nausea, headaches. So yes, any person can ask to leave a hospital right after a surgery, but what we'd try to do is educate patients and families on the fact that you need to, once you've been exposed to these high levels of medication like propofol, which we all know historically this is deadly, like ketamine, like Precedex, no, I wouldn't let somebody just walk out of a hospital once you've had those medications on.
This is the Patient's Rights and Responsibilities, Johns Hopkins Hospital. You see that?
Yes.
Are you familiar with it at all?
Yes.
Did you have any present fear for her life if she did not remain in the hospital?
Yes.
And number 20 says refuse care. She has the absolute right to refuse care, and so do her parents. You see that?
Correct.
And they refused your care. They wanted her transferred to Nemours, right?
So I spoke to an ICU physician at Nemours who stated that after reviewing our medical records along with previous medical records, in conjunction with discussion with their pain team, a decision would be made about accepting the patient.
Okay.
So I actually followed the parents' wishes and made a referral.
Yeah, but your referral was based on a Munchausen by proxy psychiatric referral, not on a comprehensive.
Oh, no, absolutely not.
CRPS.
No, my referral was on the diagnosis of CRPS. Up until this point, and even after this point, because this was my last contact with the patient, I was operating under the diagnosis of CRPS.
And so one of your reasons here is the mother's reluctance to turn over medical records. Is that right?
Yes. Mom agreed to obtain all her records from Dr. Hanna and Dr. Kirkpatrick and stated that she would send them directly to Nemours.
Okay.
We asked if the records could be sent to ACH, and then we would send them as a complete package with our records, but she stated that she preferred to send it to them directly.
Okay. So she was willing to send out the medical records to Nemours. What's the problem there?
We undertook the care of Maya, and we were continuing to undertaking the care of Maya, so it was a reasonable request that we see the records.
But she didn't want you to take care of Maya anymore, and they told you they didn't want you to take care of Maya anymore. They wanted you to simply transfer her to Nemours, correct?
Which is exactly why I made the referral.
Okay.
And we were told that they would make a decision.
Well, so why not just leave it there? You have made the referral to Nemours. They don't want to deal with you anymore. And you don't want to deal with them anymore, apparently.
Well, that's not true.
But they don't want you taking care of her anymore. They want to get as far. Did you understand they wanted to get as far away from ACH as possible by this point? Did you understand that at all?
I understood that the family did not agree to our treatment plan, that they did not like the fact that we weren't willing to escalate the medications beyond our agreed treatment plan, and that they wanted to leave, yes.
Because they had the right to leave under your own patient statement of rights, correct?
Yes, absolutely.
But they didn't get to leave, did they?
I don't know. I was done taking care of the patient by Monday morning.
You say mother's reluctance to turn over medical records. I don't see anywhere here where you required, demanded, or put in front of her a medical authorization to do so.
Form.
I didn't write the words, but part of her not agreeing would be her not signing the release of information.
And so now you stick in here the fact that the child is receiving highly mind-altering meds. What's the highly mind-altering med?
A combination of the propofol, ketamine, and Prestex.
That you guys were giving her?
Correct.
Okay. That could lead to withdrawal. Do you have any evidence anywhere in the record that this child experienced withdrawal symptoms from any of this, ever?
No, that's why I wrote could lead to withdrawal.
Well, ketamine has no physiological withdrawal effects. You are aware of that.
High doses for a prolonged period of time, I don't think you can show me evidence that it doesn't.
Where is any literature, I'll represent to you, the experts have looked at this long and hard, where is there any study that, other than pop science and junk science, like Psychology Today or something in the newspaper, where is there any study that shows that ketamine has a documented withdrawal?
One of the things that we're discovering with medicine recently, where we thought that ketamine didn't have long-term side effects, is that no, in fact, long-term infusions can lead to withdrawal. I don't understand your question.
Did you look at any studies or research before you made the assertion in here that mind-altering meds that could lead to withdrawal? Where was the psych consult in... Where was the psych consult?
Mom has already refused psychiatry to speak with Maya multiple times.
Why didn't you just let these people go? If they wanted to go and your own patient's rights say they can go, why don't you just let them take their child and leave the hospital?
Because in order to let someone safely go when they've been on this type of medication, you don't want to just abruptly turn it off and then pull out the IV and let them walk out.
Why not?
Because you want to watch for side effects. You want to make sure that you, to the best of your ability, have accounted for anything that you could have done to them while they were receiving this medication. So if, for example, that this medication caused them to retain urine, okay, sometimes your bladder becomes hypertrophic, and so now you're holding onto urine, and so it's exacerbating your pain. That's because some of this medicine is it's still in your system. So now you have to possibly get a Foley. You need a urinary catheter placed so that you can relieve urine. Like I described before, the nauseous and the headache side effects of this, which could make you unstable to walk. Then you crack your head because you fall on the sidewalk. It's just not safe to get heavy dose anesthesia, stop it, and then walk out of a hospital.
If you were so concerned after this, when did you become concerned about them leaving the hospital?
Sunday evening.
How long did you feel you needed to observe Maya coming off the meds?
When you're on that type of medication, probably half a day.
So she could check out the next day?
If everything got sorted away and Nemours accepted, yeah.
What if they say, we don't want to go to Nemours anymore, we don't want to drive up to Orlando? They just wanted to leave.
Yeah, I mean, there might be differing opinions, but my personal opinion, half a day, yeah.
So why don't you stop the medicines on Sunday night? They didn't agree with your treatment, and they wanted to get their child out of there. And then you see how she's doing by noon the next day and let them go. Why not do that?
Because we were still treating her pain. They were obviously insistent that we escalate. I'm not going to completely stop everything, especially if you're telling me that you feel like she's still in pain. And the initial plan that we agreed upon on Friday night with the family is that we would go till Monday morning. So I was sticking with the plan. We'll go till Monday morning. You feel like things haven't improved. I'm going to make the referral to Nemours. We'll wait to hear what they have to say, and we'll take it from there.
We just saw Jack Kowalski engage in any deception with you, did you?
No.
And you never really saw refusals by Beata, but you never saw Beata trying to intentionally deceive you, did you?
We were waiting on the referral from Nemours.
You'd been on duty all day?
Yes.
Okay, and you'd had a disagreement with them? You'd had a disagreement with the Kowalskis in that meeting about the type of treatment, right?
Yeah, about escalating care and the inability to provide records. That what?
There is a lack of correlation with certain treatments and the patient's perception of pain.
Yes.
Okay.
We were aware of that, yeah.
And, so tell me the symptomology between CRPS and Munchausen by proxy.
Well, I can tell you the symptomology of CRPS.
Okay, tell me that.
Well, one, it's going to be generalized. It's going to be regional. But you can have a variant of generalized.
Okay.
All right. So we're already stating that even though the fact that most of the times it's regional, she's presenting as this very generalized pain. It's not in one place. You're also going to have autonomic dysfunction. You're going to have some type of either sweating or swelling of the extremity, temperature differences.
Did you do a thermography?
I don't believe that there were, since her pain was generalized, there was not one place that we could put the temperature probe.
Prior physicians had measured the left arm from the right arm, the left leg from the right.
Well, in this acute presentation,
the right leg, right foot from the left foot. Did you do any measurements that way?
No, her pain was generalized, so no, we did not.
Okay. What else?
And then just the fact that the pain is going to be out of proportion to your physical exam findings.
Right. Allodynia?
Yes.
You noted that. But you had that.
Did I note that?
Yeah. And you just said it like 3 times.
Yeah, generalized pain, yeah.
But also the pain was out of line with what you would expect.
Yeah.
Okay. Which is known as allodynia, is it not?
Yes.
Okay. And that's a chief symptom, one of the big 4 symptoms, is it not?
Yes.
Okay, and so she had pronounced dystonia in the feet, did she not?
She had an inability to stand up. Yes.
Okay. But her toes.
Dystonia implies tone, and I couldn't examine her. Right? She wouldn't let me touch her because she was in so much pain. So I can't comment on dystonia. Dystonia is a physical exam finding. The inability to walk, pain to walk, is a symptom. She's reporting a symptom versus an actual physical exam finding.
Well, you get a look at her feet. She came in a wheelchair, right?
By the time she was in the ICU, she was already on an ICU bed.
Okay. Did you ever look at her feet to notice there are photographs of her feet like, and I don't need to make this an exhibit, it's already an exhibit to a bunch, like this, feet turned in, like this in the hospital?
That may or may not have been the case when she was in the ICU.
Okay. But you didn't specifically look for this?
I wasn't the one that did the history and physical note.
Okay.
I mean, I don't know if Dr. Tedma's note mentions it.
That's a classic CRPS symptom, is it not? Dystonia?
I'm not an expert enough to know if it's a classic symptom.
Can you take a look at number 6, exhibit 6 there? Particularly page 6 of 8. I'm just asking him about one specific additional part of it, and that's at page 6 of 8 under skin.
Mm-hmm.
Have you ever seen complex regional pain syndrome lesions?
No.
Did you have access to this page before, or this report? And what is this report? This is the
anesthesiologist.
Anesthesiologist report. On the skin it says 4 discrete round raised papules present on lower back. Do you see that?
Yes.
Are you familiar with complex regional pain syndrome lesions? What they look like?
No.
Was there ever any discussion, given the identification of these, to compare them to the literature to confirm these were an objective finding as to complex regional pain syndrome?
No.
And Dr. Malik and the other doctors don't feel the child meets the criteria for RSD. Do you remember saying anything about that?
I remember saying that some of the findings were inconsistent.
Would you classify the relationship by the end of the evening Sunday as hostile between you and Beata Kowalski?
No more hostile than I've experienced with other families that may disagree.
Okay. Well, if you were going to describe it, how would you describe your relationship?
She didn't like me.
Beata never said put Maya in a coma. You couldn't put her in a coma in that hospital, right? You weren't set up to do a...
No, we do surgeries every day. We can put someone into a coma. We place people into a coma, and I believe those were her exact words when she came to the emergency room. When I received a phone call from the ER, I recall, said that she wants to put Maya into a coma.
Okay, for what reason?
To control the pain.
Okay, coma meaning under general anesthetic.
Yeah.
It's not really a coma. It's just...
Semantics. General anesthesia, coma, they're the same thing.
Did you ever tell anyone at the hospital Maya's not in any pain?
No.
Mm-hmm. But I want to make sure it's not your testimony here today to suggest that if in fact there was a question and it was phrased in a way that Dr. Smith was part of a hospital team, that you believe or represented Dr. Smith was a treater here at the hospital for Maya.
No, Dr. Smith was one of the people that we contact to start the process of the investigation, but and that's who I got trained to contact, but she was independent of Volt Children's. Right. I knew that she worked for the county or whatever. She covered multiple hospitals.
Right. So not to put words in your mouth,
yeah.
But if I'm understanding you, you understood her to be and understand her to be a consultant that can be utilized by folks at the hospital if necessary regarding pediatric potential child abuse or neglect.
Yeah.
Maya was not only on ketamine during this 3-day period that you were involved in her care, she was also on 2 other pain medicines, correct?
Correct.
And what were they again?
Precedex and propofol.
What is Precedex?
That's the trade name. The generic name is dexmedetomidine. It could be used as a continuous infusion like ketamine and propofol, basically for sedation and analgesia. So it's an anesthetic.
Are there any, strike that, what are the potential ramifications of the abrupt cessation of Precedex in a critical care setting?
Everyone responds differently to anesthesia, but some of the potential side effects include things like urinary retention, nausea, vomiting, headaches, breathing issues, blood pressure issues.
Did you have any concerns about the cessation, the abrupt cessation without a tapering schedule of Precedex as it pertains to Maya Kowalski's care and treatment?
Yes.
Who were some of the other providers that would have been giving you updates or expressing issues related to Maya?
Her nurses, nurse practitioners, physician assistants, social workers, pharmacists, nutritionists.
Do you have any specific recollection of what any of the nurses told you in the PICU on any of the days that you were involved?
I remember that they were talking about the inconsistency with how she reported her pain when the family was in the room versus when they would ask her outside of the room.
And that completes the playing of the
It does,
deposition.
Your Honor.
And at this time, is that all for today for the jury?
We would like to publish the last 3 remaining emails from the commissaries if we could before we conclude today.
Let's go ahead and do that real quick.
Okay, so the defense would publish Exhibit 3147. And this is email Beata Kowalski to Beata Kowalski, 11/22/15.
Anyone need any more time?
Okay, the next one, the series judge is Defense Exhibit 3150. And this is day 6, November 24th. Actually, day 6 in the criminal is 11/23.
Anyone else need more time? Just a little bit more time. Anyone else need more time? Your next one, please, Mr. Shapiro.
Yes, sir. 3148. And this is November 25th, 2015, Ketamine Coma Day 7.
Anyone need more time? Okay, more time. Looks like everyone's okay.
That will likely end the defense presentation for today, Your Honor.
Okay, members of the jury, I think this is a good time to say goodbye today. Do not discuss this case amongst yourself. Do not do any investigation. You receive no information. 9 a.m. start time for the jury tomorrow. Have a wonderful evening.
All rise. Jurors exited.
Thank you. The jury's out of our presence. Everyone, please be seated. Let's finish up on the issue that we were discussing before we took the deposition.
Regarding the prescriptions?
Prescriptions, yeah.
Yep, the prescriptions were filled out.
They were filled?
Yes, sir.
And are those records and evidence the pharmacy records?
They're looking, but it sounds like perhaps they were admitted unless they're attached to something. Are the emails part of? The emails are part of them, which is this one? I guess there's email correspondence confirming it. I don't know if the actual record is, and perhaps we could provide to the plaintiff's counsel and see if they have an objection to us adding it at this point. We'll send it to you. It was, I believe, an attachment to Mr. Schott's deposition.
It was actually to Jocelyn Krager, who's another Quorum pharmacist, who was an attachment to her desk.
It's been disclosed to plaintiff's counsel before trial, but I guess inadvertently left off our list.
Mr. Schott has also testified it was filled. Mr. Schott has email correspondence indicating it was filled. And the internal Quorum pharmacy records indicate that the lot was filled on 2 different occasions. The lot is also known as hyphen with phone.
Are you looking for a response, John?
Yes.
There's no exhibit number on here. They've handed me a patient medication profile from Quorum. It is Bates stamped. It says start date, stop date. It looks like it was, if filled, stopped by November 13th or November 17th. There's 2 indications here. So it was about a 2-week period. If this record is accurate, we would maintain that Dr. Kirkpatrick already testified that he was trying to get her some acute medication to get down to Mexico, and it's not relevant to anything that's going on here.
We would just call the witness to have them verify that this is the medication list from your company. These are the medications you filled. I can tell Your Honor how, I know what Your Honor's concerns were at the bench. I'm happy to disclose how I would argue this to the jury if you'd like to hear.
Yes, please.
Yeah, sure. So for example, in a closing argument, I would lay out to the jury, here are the medication profiles that Maya required for her pain through this period of time, even after the first doses of ketamine given by Dr. Kirkpatrick, which you've heard were 1 milligram per kilogram per hour, then 1.5, then 2, can't remember if we went up to 3. Those failed. Yeah, 3 milligrams per kilogram per hour. Those failed. The patient still required these, what we would consider to be significant good doses of hydromorphone, opiates, to get her through and crutch her through to Mexico. Then she required the ketamine coma in Mexico. As we've seen from the blogs, there were what we would consider complications and significant ones. And then she still required significant doses of ketamine from Dr. Hanna that eventually increased into September and early October of 2016. And then All Children's, once she got into the ICU, as you heard from Dr. Malik, started to wean her down off those medications. Ladies and gentlemen of the jury, what we would submit to you is after she left All Children's Hospital and continued with the practice of just physical therapy, occupational therapy, and perseverance and time, without these medications, she was able to make a substantial recovery. So we would be able to contrast with the jury that the medication she was on during this period of when she was in the wheelchair was hampering her rehabilitation. Contrast that to All Children's taking her off these medications and showing how well she's done. And we believe that's very important to the defense, especially when they have a vocational rehabilitation planner who said that her course of treatment was accelerating her, to an A+ course. And because of All Children's aggravation of an injury, now she is either partially or fully disabled.
Anything further, Mr. Whitney?
I think the only thing that I need to respond to is to point out again that the argument that was just relayed there requires us to get into the reason the ketamine was no longer provided to Maya Kowalski upon discharge. They clearly did argue that, well, I'll leave that there.
Well, on that issue, I think I've said on multiple occasions, your clients can testify as to what they understood or what they felt or what they were fearful of if they were to get ketamine again. I mean, I think I've said that, 4 times now? So I feel like that issue, there's a path for you to address. Now, going back to the actual pharmacy or the script, redacting out that information about terminal illness, I'll go ahead and admit it.
Okay, thank you, Your Honor.
I don't know what number that is, so can you, and we might need to do an A because you're going to redact it, so perhaps in the morning, let's do it so the clerk will have the actual redacted version.
Yes, Your Honor.
Do we have, Mr. Sorensen, a time?
I have it, Judge.
Ms. Crowell.
For the Malik death, or Malik
Yes.
death, defense, 11 minutes, 10 seconds. Plaintiff, 18 minutes, 20 seconds. And then Green, which is the combined both, 20 minutes, 35 seconds.
Let me do the shot clock. The plaintiffs consumed 1 hour, 20 minutes today for a cumulative total of 55 hours, 20 minutes. 5 minutes today for a cumulative total of 35 hours, 10 minutes. What's tomorrow? I know it's Friday, but who's coming tomorrow?
I think I announced it earlier. Dr. Jennifer McCain is a psychologist from Tampa General. Mr. Schott, the pharmacist. And Mr. Bankert, he's our billing and coding employee. He's not an expert, but he's going to explain the billing issues. We originally were going to have him last week, and then there was a discussion about directed verdicts. Then we anticipate being able to play the depositions of Dr. Hanna and to play the deposition of the guardian ad litem. Is that right?
Yeah.
That should be a pretty full day. I would
No,
think.
guardian ad litem, yes, we didn't have any objections, the judge has already ruled on the other ones, so it just needs to be edited.
So 3 live witnesses, 2 depositions as we can, and we might need to have a short discussion at the end of the day about the scope of, and I'll wait for Mr. Anderson to be here, but we have our child abuse pediatrics expert that mirrors Dr. Newberger, so just so I can prepare him over the weekend about permissible scopes of testimony.
Tonight is, I saw that there was some objections for a deposition.
Dr. Bose.
Dr. Vos?
Dr. Bose, the first deposition.
Now, do we need that for purposes of tomorrow?
No.
Okay, so I don't need
Take it
to,
off, Judge.
well, it's not that, I
No,
just,
I know. But no, I think between those witnesses, Hannah and the guardian ad litem depth, I think that will fill tomorrow, Judge.
anything from the plaintiff side for tomorrow that we need to talk about?
We need to discuss, we'd like this deposition now so we get to the bottom of Dee's performance review.
When do you want to do that?
So we'd like to do that this weekend. And keep witness Anderson on recall. And then just reiterate again, we're waiting for a opera decision so that Mr. Elegant can work on the verdict form and instruction.
Are we at a decision point yet on Fabre?
I think Mr. Altenburn has that answer for Mr. Altenburn. We'll be discussing that with Mr. Elliott.
First, we can advise the court first thing in the morning. I know Your Honor's thinking, we're going to advise the court first thing in the morning.
I need to get final proof, Judge.
That's fine, I appreciate that everyone has to check with whomever they need to check with.
Judge, if you do have one exhibit we could take care of.
Sure.
Well, it's one that we had previously discussed, it's 3217. Yeah, that'd be fine. The one where they said we want it all before in, if you're gonna put the part in. So there's only one, so, is that highlighted, Mr. Whitney?
Yeah.
So Mr. Whitney has highlighted what he wants redacted. I'm fine with all of it except for on 0572. He wants to at the bottom there, he wants to remove due to the case being brought up and mention of the judge and his decisions. I just think it needs to be in there because it doesn't talk about what substance is, just that's why I had to redirect you. That's the only highlighting that I don't agree with. The rest we're happy to redact.
No, we need to redact that.
Okay, so we would stop at, on the phone, I had to redirect.
And it's been a full day since I've looked at it. Is there anything in here by implication that's going to get us in trouble on the gravity of Chapter 39?
No, I think that's why he's redacted the other things.
Those are my redactions.
So we're happy to do that. We'll redact it and have it ready for the morning.
Thank you. And speaking of the gravity of Chapter 39, I wanted to say how much I appreciated both sides trying to live within the court's order with respect to Dr. Sally Smith. And, you know, I think she said trying to thread the needle. And so I appreciate both sides working. And I know you disagreed with some of the court's rulings on it, but I do appreciate y'all trying to stick to what we had talked about. Thank you.
Thank you, Your Honor.
Anything else we need to discuss today?
I don't think so.
Is 8:30, or do you, I mean, how much time do we need tomorrow morning? Do we need a full 30 minutes, or
I don't think so.
would you like to come at 8:45?
No, I'm just going through the witnesses real quick in my mind. And I think 8:45 is fine. So yes, we should be fine at 8:45. Would you think so, Mr. Wynn?
Ms. Lawrence had like a big smile on her face.
8:45 is fine from the defense, John.
Then 8:45 tomorrow morning is when we will reassemble. And look, it's not even 5 o'clock yet.
And we got Dr. Malloy. I'm considering that a success, Judge.
Okay. We'll be in recess. Have a good night, everyone.
Thank you.